It's our first day of the public hearings. We have a full program for today. Just before we start, we would like to deal with some housekeeping issues which have necessitated not anticipate that there will be a joint sitting of Parliament or for tomorrow, and we did not anticipate that there is going to be a motion of condolence that affects some of the members who served in this committee, like Advocate Hisham Mohammed and another member of the NCOP who used to also serve in this in the security cluster in the NCOP. So from 2 o'clock today, we would be attending the House for the condolence motion, and tomorrow it would be the debate on the president's recovery plan, and on Thursday it's questions to the deputy president. So we would try and ensure that Friday we would push as much as we can, but it's quite clear that some of the presentation or is some of us working on that to have revised the program. Would like to apologize to especially to the stakeholders. It was unanticipated that we would have changes in the program in the manner that they have happened. So today we have the following organization: National Congress Women's League, and then the Children Institute, and then COSATO, the South African Police Service, and then tomorrow in the morning it will be freedom of religion in South Africa, South African Women's in Dialogue, Research ICT Africa, a rape crisis, the South African Institute for Advanced Constitutional and Public Human Rights and International Law. And then it will be Lisa Vetten and others. And then after that, we would adjourn. Honorable members, we would give the African National Congress Women's League 20 minutes. They will be covering all the three bills. And then thereafter, it will be questions and answers for 30 minutes. Questions are having had all the people who would have presented before us. So the questions are merely for us to understand the presentations in detail. So it's more of clarity seeking questions. So, honorable members, I think let's start by inviting the African National Congress Women's League. Already we have taken 4 minutes of their time, but they will not lose Women's League. So, honorable members, I think
Good morning, Chairperson. I am the lead of the team of the ANC Women's League to come and present the bill. So you will let me know. Should I proceed, Chair?
Yes, good morning.
Okay.
And welcome. You can start now.
Okay, thank you very much, honorable members, for inviting the ANC Women's League to come and speak to these crucial bills in this morning. And then I will go to, I'm not sure in terms of presentation, I will introduce the team. My name is Advocate Nomazo Chomemani. I'm the legal practitioner and the gender activist. And then in the queue, we've got Advocate Notemba Mlozi, who's a legal practitioner and gender activist, and Advocate Ntabi Singh Sipanya Mukhale, legal practitioner and gender activist. And then we have the young advocate as well, Sandra Makwasha, who's a legal practitioner as well as gender activist. And then we have Miss Kwerano Mpamunyane, who's a legal practitioner as well as a gender activist. She's also in the Young Women's Desk. We have Miss Pili Lenduli, who's a PhD student and a gender activist. And then amongst this team, we also have Ms. Toli Ngwenya, who has a BA Political Studies and LLB, and then she's also a gender activist. Our slides, the ANC Women's League welcome the process and the legal development and transformation in the country. And then we've noted that some of these legislations are very old, and they were appealing to the legislature to please attend to that. And then we further appreciate that all these bills intend, and then we further hope that these bills will be financially supported, because that is the key. We will deal with our bills in the following manner, and then we'll start with the criminal law, sexual offenses and related amendment bill that will be presented by Thuli Ngwenya, Notemba, and Nomazocho. And then we'll follow up with the criminal and related matters amendment bill that will be presented by Ntabiseng Mogale, Sandra, and Notemba. And then we will do the domestic violence bill that will be presented by Correctional, Mpomanyane, and Pilile Ntuli. And then the other, the one person will be presenting, and then the others will also be responding into the questions. Thank you. Okay. Thank you very much. Okay, I think this one is in detail. It's because I was told that I will only be talking for 2 minutes to can come, and then we'll start with, as I've indicated, we'll start with, I'm sorry, I'm just checking the name. Sorry, sir, can you just please put me into the bills as well? Or we'll start with the sexual, okay, with the sexual, we'll start with the criminal offenses bill, and then I will hand it over to Thuli. I think it will be presented by Thuli in terms of our program. Thanks, Chu.
Thank you very much.
Good morning, colleagues. I hope you can hear me. As indicated by our comrade, my name is Tolithe Ngwenya, and I'll be presenting the submission on behalf of the ANC Women's League on the Criminal Law, Sexual Offences and Related Matters Bill to Parliament. As the ANC League, a Women's League, we hold the view that the objectives are well articulated in the preamble and adequately address the importance of codifying laws related to sexual offences. However, there are some proposals or submissions that we'd like to make in relation to the Act or Bill in general. The first one would be in relation to the scope of the register. Our understanding is that the Sexual Offences Register offences. However, at this particular point in time, the narrowed focus of this register in dealing primarily with employment register should be extended beyond employer and employee relations and look into offenders who actually do come in contact with vulnerable persons in instances outside of employment. For example, we have individuals that have access to vulnerable persons in voluntary positions, such as orphanages. Another problematic aspect of the current sexual register is that it places the state's obligation to protect vulnerable individuals solely on the employer and strangely on the goodwill of the offender through duties to report their own conviction. This on its own is problematic and of course enforces the idea that the justice system is one that is perpetrator biased and doesn't look into what the victim could be going through. What also emerges in terms of what we'd like to propose in relation to Section 2 of the Act and making an amendment where we speak to persons who are vulnerable. We believe as the ANC Women's League that the definition of who's vulnerable should be expanded. The suggested amendment to broaden the scope of those individuals who may be vulnerable to sexual violations from being just children and persons with psychosocial disabilities is welcome. We are of the view that this act, however, needs to be more specific when it speaks to persons who are vulnerable. The inclusion of elderly people should be looked into, people with disabilities, people with mental health illnesses, the LGBTQIA+, women and children. This will ensure that all marginalized groupings in our society are actually protected by the law. There's a further level of vulnerability for women, of course, who do not have access to social capital in our society as it stands, and therefore can't just leave their partners. These are persons that are most affected by gender-based violence, and they're found in the shelters where they're catered for. In terms of this national register and the bill, persons working in these shelters would ordinarily not be screened for sexual offenses unless they're children in the shelter. This is highly problematic as it creates a situation where vulnerable groups such as women, who are mainly the victims and survivors of gender-based violence, only gain protection under the National Register by proxy of their children, as they're not included in the current definition of the Act. Hence, we propose for it to be broadened. We'd also like to speak to Section 5 of the Act, which is part of the LGBTQIA community, are protected from sexual assault irrespective of the perpetrator's gender. In this way, everybody will be held accountable, even in instances of intimate partner violence, where you would find that people are of the same gender. The final issue that we'd like to raise in relation to persons who are vulnerable is related to the provision that speaks to a young person under the age of 25 receiving tuition at a higher education or private institution. Under this definition of the Section 1 of the Higher Education Act 1997 is deemed to be vulnerable. The bill suggests that the above person is only vulnerable or sufficiently vulnerable until the age of 25. This is an arbitrary age and does not seem to be based on research around vulnerability and linked to age. A person who's attending a higher institution of higher education still experiences levels of vulnerability, whether under the age of 25 or over. It must be remembered that age is not the sole determining factor in relation to how vulnerable the person is to sexual violence. Lastly, we'd like to then focus on issues under the repercussions for perpetrators and what our contributions are as the Women's League. We are of the view that as it stands, the community at large has little faith in the justice system, or how ineffective, have a view that the justice system as a whole is ineffective. We feel that this can change in the following ways. The police as it stands are the most basic unit of the criminal justice system. However, when victims of sexual violence go to the police station, they go on to experience secondary victimization, yet the police are supposed to be playing a crucial role in terms of that. We feel that in the Procedure Act must be amended to place all GBV offences under Schedule 6. This will assist in making sure that it's difficult for the accused persons to be released on bail. In much as the public may have a misunderstanding of the bail system and its purpose, this will help give a public confidence when perpetrators are not released often. And this will ensure that we don't only look at cases that are famously reported in the media. We'd also like to propose that the NPA must issue a directive in addressing a structural and a systemic issue of gender-based violence, as people could take that into consideration before committing acts of any form of gender-based violence or sexual offenses. We therefore need to ensure that all GBV offenses are codified, and also that we include them in the more concerted effort must be placed on fixing systemic issues, such as ensuring that the legislation is implemented, and also we need to make a more concerted effort in ensuring that we expand the definition of the people who are affected by acts of sexual offenses and gender-based violence. Thank you very much.
Thank you. I think the next speakers must also mind time, because we are going to be straight with time today, because we are under a lot of time pressure. Advocate Mukhale.
Thank you very much, Chairperson. We as the Women's League welcome this opportunity. I will be presenting on the Criminal and Related Matters Amendment Bill, which basically touches up on amendments in relation to 4 legislation: Magistrates Court Act, Criminal Procedure Act. Anything that we do not amplify in any way means we do agree with that. So that should be noted, but we would like to hone in on some of the sections where we have inputs. The first one would be Section 51A under 1C. We are saying verification of complainant with biological and mental age of 18 years and below. We say the state should take responsibility in relation to that verification, just as much as the state takes responsibility in relation to accused persons in criminal matters in line with Section 77, 78, and 79 of the Criminal Procedure Act. We are emphasizing all these three sections because we're saying the assessment, the allocation of a doctor for assessment, and the bringing forward the completed report to court must be the responsibility of we're saying it is a good proposal. We support it fully, but we would like to emphasize that the head of court, who is going to be tasked with appointment of intermediaries, must ensure that it's actually auxiliary workers, so that they are held professionally accountable to a particular professional bodies or at least organizations. So counselors attached to organizations must be the people who are actually prioritized. We further propose that a security clearance in relation to previous criminal records or even current must also be considered, but not necessarily related to debt, because we understand the dynamics of how women end up in debt, which then becomes a situation that is outside of their control. In relation to 4B, we are emphasizing that much as it's good to appoint intermediaries, we must have a huge number, that is a minimum number of persons at any one time that will be allocated to courts, so that we avoid unnecessary postponements which result in secondary victimization in sexual cases. These intermediaries, we're saying, must be multilingual, especially in South African languages, but particularly in SADC languages, because of the taking into consideration those areas that lie alongside SADC borders. We then move on to point 8, still under 51A. We're saying it is a good suggestion that the recordings and reasons be given why an intermediary is not appointed in cases where it should be, or because those should actually form part of an appeal should people wish to appeal the situations where intermediaries were not appointed and they feel that has actually disadvantaged them. We then move to 51B, where we're talking about code of conduct of intermediaries. We are suggesting that the code of conduct must take into consideration all the issues that we have raised about how they are appointed. Moving to 61C, we're saying evidence through audiovisual links is in proceedings other than criminal proceedings is very helpful, because it will do away with a lot of backlogs, but it will also bring to a speedy resolution of cases involving people outside the Republic. However, it must be borne in mind that there are people who cannot afford any technical gadgets or equipment who are in relation to those in South Africa or in far-flung areas. So this should actually not be a norm, but something that is carefully selected to enable justice to be meted out fairly. We then move to the next bill, to the next act, which would be amendments proposed in relation to Criminal Procedure Act 51 of 1997. Under Section 59, we support this because it now has amplified domestic violence and harassment as crimes that must be taken seriously. We appreciate that. Under Section 59A, in relation to bail, it says the DPP may authorize release on bail. And I think this may, we do understand that it is as a result of Section 35 of the Constitution that says bail is actually a right, and it is not a form of punishment or rather a sentence. However, we are saying with regards to issues of domestic violence, we would like the same high standards that are used in Schedule 5 and 6 offenses to be used with domestic violence when bail is applied. In a nutshell, we are saying we would like the courts to consider bail only under exceptional circumstances and take into consideration the entire Section 60, but we are also including the type of crime, societal perceptions and expectations of justice, which is quite a big issue among domestic violence issues. Period of violence. We are cognizant of the fact that sometimes the courts take an assault as a once-off event, but rather women must now be allowed to say this has been going on for 5 years, and therefore, if this person goes out on bail, they will come back. And ongoing threats to complainant and their families, because we know that how gender-based violence in particular manifests itself with the harassment of all of those around the complainant. With regards to Section 60, we are saying it must also mention or related persons, because some parts of the Act does mention or related persons. It is critical that this be uniform, that all the threats, all the protection orders and everything should be about the complainant and or related persons. We say Section 158 is very progressive. It will also deal with backlogs and cold cases. Moving to Section 316, we say it is a good suggestion. However, we would like the Act to define what we mean by grave failures of justice, so that the implications are monitored and picked and proper action is done. Otherwise, it actually is going to be a toothless provision if it is left like that. We would like to know what the Act means by grave failures of justice. Proposed amendments to Schedules 1, 2, and 7 are correct and supported in both Parts 1 and 2. Amendments to Part 3 of Schedule 2 is inconsistent with all other laws where a child is defined as under 18. Here, it defines a child under 16. We would like that to be corrected, because then it is going to cause problems in terms of implementation, especially in the courts. And this would have been, unfortunately, after the fact when a crime has been committed. So we're saying all the acts must be in line with the Children's Act. That as a child is anyone who is 18 and below. Moving to the third piece of legislation, the amendments proposed are also welcome. We also emphasize that it should include related persons in all of the provisions that say complainant. It must be complainant and or related persons. The section 15A3 also talks about the age limit, but it says 16 or 17, and we're saying it must go to 18. But we also are saying Schedule 2, we're emphasizing that 18 years should be looked within a context, because it is talking about people with mental disabilities. A person with a mental disability may be 18, but having a mental disability of a 9-year-old. A person with a mental disability may be 22, but having a mental disability of a 9-year-old. So Part 2, Schedule 2, should actually, and Section 15 should be looked at in terms of context, and proper resources to be made available for the mental age of a complainant to be fully and professionally confirmed. Lastly, we looked at the Superior Courts Act of 2013, and we agree that the amendments proposed by this Act under Section 37A, 37B, and 37C are welcome, and they will deal with challenges that arise where people where people can access justice through technology. But we again caution that the Act should always be aware that this should not be made into a mainstream or only option, but rather be made into one of the many options that people can use to access justice. On the overall, and in conclusion, with regards to these 4 bills, we are saying they are progressive in that they recognize the limitations of older persons and persons with physical and mental vulnerabilities, which in so many ways is a first, because sometimes legislation tends to take everybody as fitting into a particular category and not considering others. Now parents and relatives can go forward and feel comfortable that they will be heard where these limitations are picked up. The issue of bail has still got to be amended further. The current proposed amendments may not be sufficient to ensure the safety of complainants, especially on matters of GBV, but we have sponsored ideas on how this could be attended to. And as we have pointed out, it is already an existing measure of Schedule 5 and 6 offenses, so it will be easy to apply. There is, however, a need for monitoring of all proposed amendments to ensure effective and efficient implementation. With those few words, I would like to once again thank you for the opportunity that you have given us as the Women's League. Thanks very much.
Thank you very much. The last one, I think we can only give you 3 minutes. Your time is up.
Thank you so much. In the interest of time, Chairperson, I'm going to just narrowly go through the definitions. It is noted that the reason why the ANC Women's League has considered such imperative changes to legislation is to, one, update legislation to deal with patriarchal impediments that continue to secondary victimize victims that suffer at the hands of people that have abused them and perpetrators that continue to inflict domestic violence upon them. With that said, we suggest the following definitions and additions into the bill. Definition 2B into the definition of the child to align itself to the age of 18, as well as that definition as given in the Children's Act and also the United Nations Convention on the Rights of the Child. The definition of coercive behavior to also include extortion, blackmail, torture, humiliation, dehumanizing acts, and threats to induce favors. The definition of controlling behaviors is also amended and upgraded to include overactive jealousy, belittling, teasing, ridiculing, uncomfortable sexual acts, and also acts that could put the children's life in danger, such as stalking and manipulation. Definition of damage to property to include both movable and immovable property. As Section 2IG, to remove stalking for the substitution of spiritual abuse, we propose that stalking should not be removed from the bill, as it can be part of an act of domestic violence. And it also is important to note that stalking remains under the protection of From Harassment Act 17 of 2011. We believe that this should be kept within the act. Exposing children to domestic violence at 2IH, where domestic violence includes exposing children, it is proposed that such definition includes other related person to also cover people in addition to children that suffer from a limited mental capacity, and also people without necessary and requisite capacity to act on their own. The definition of emotional, verbal, and psychological abuse to additionally add the direct or indirect abuse through the use of social media and other intended electronic means. Section 2A, the Women's League would like to support the establishment of a duty to report the acts of domestic violence against children, persons with disabilities, or older persons. However, we want to caution that we need to practice this into imposing an obligation to report when these acts are committed, and make sure that we do not criminalize the failure to report these acts of domestic violence, because it could indirectly limit the agency that friends and family have, and therefore causing them not to have necessary buy-in. Substitution of Section 3 into the Act, we suggest and table and make a submission that the amendment suggests that peace officers are obliged to arrest any persons whom they reasonably suspect of committing acts of violence. While this provision is welcomed for its extension of protection to victims, we need to exercise due caution, because peace officers and members of the South African police officers need to make sure that systematic inhibitions that remain a problem today do not prevent them from carrying out their actions. Just in retrospect, to go over some of the important things that we think that we want to make as suggestions, the ANC Women's League generally welcomes all amendments made in terms of Section 4. And also, in addition, we propose that Section 4.3a be further amended to remove the word material, so that it reads as such: notwithstanding the provisions of any other law, the application for a protection order by any other person who has an interest in the well-being of the complainant. The case for the application of protection orders by GBV victims must be prioritized in our local courts, as the chances of the perpetrator coming back to continue this abuse are often high. We've seen this in experience. And finally, we do this with the submissions with the inherent hope and belief that the law needs to be revised to ensure that we leave no one behind, and therefore we propose that a specified time period be substituted for the word reasonable time, because this is an urgent matter. The ANC Women's League would also finally holistically welcome the amendments introduced by the Domestic Violence Amendment Bill, and the suggested changes have the potential to shift the trajectory of relationships between victims of domestic violence and the law in general. It is further important to note that the problems that are facing South Africa's struggles with gender-based violence are structural and systematic, and therefore suggesting that in the absence of structural overhaul that radically shifts economic, political, and relationship dynamics from men to women, the status quo may remain the same. So this is our submissions. Thank you, Chair.
Thank you very much. Thank you very much. Thank you for the presentations. I will now open this time for honorable members to ask clarity-seeking questions. We have 30 minutes to ask the presenters any questions, just for the purposes of seeking clarity. Over to you, members. Honorable Jelle.
Sorry, Chair. Good morning, presenters and the team. And Chairperson, I'm sure we didn't do an introduction, but anyway, my name is Noma Themba Maseko Jele, member of this committee. And we appreciate and welcome the presentations. But only one clarity question, Chairperson, that I might have on the criminal offense. The first presenter, he mentioned the issue of age. I wanted to find out maybe age 25, that they are not kind of happy with the age 25. I just want to find out, I didn't hear maybe their proposal on that one, what age, or just open it in terms of the vulnerability or the people that we are addressing today. If I may hear from them, is it do they have specific age as the proposal is 25, or maybe we'll open it, not restrict it to 25? Thank you, Chair.
Thank you very much. Honorable Yako.
Thank you very much, Chair. Mine is not a question, it's just a comment. I wonder why the ANC Women's League decided to take this long to involve itself in these bills. We have a Department of Women and Children, which was supposed to actually champion the illegalization, also the enforcement-related crimes. So for me, for them to field advocates who speak a language and a jargon that is exactly what is in the bills or similar to what is in the bills is actually quite appalling to me. I would have wished that this had happened earlier, and I would have wished that they would have been involved.
Thank you, Honorable Mufuke.
Thank you very much, Chairperson, and thanks for the presenters from the ANC Women's League. I must say that I must commend the team. For me, they have done a good job. And I think the Women's League has applied its mind into looking at these GBVs. And we are going to wait for EFF to hear them, Honorable Yaku. But the Women's League has been, and we know very well, in the forefront of this. Protection orders and the implementation, the parole system, do we still need a system that is the sexual offense register?
Thank you very much. Any other questions? I don't see any. Honorable Swart.
Thank you, Chair, and thank you for this submission. And if I saw correctly, one of these presenters is going to be admitted as an advocate tomorrow. So congratulations to you, to welcome to the profession. Yes, just in general, there's a lot of information here, and it will be very helpful to go through it in detail. I think one of the most important points that is made is the implementation of the legislation and the effective training of police and intermediaries. So I think that is an issue with a big challenge. And possibly my question to the League is how one can improve implementation. We will also hear from SAPS and others, but and the challenges that we all face with gender-based violence, if one looks at the statistics that are given in some of the other reports, such as according to the Police National Child Protection Register, the number of cases that were accepted for the register for the year 2018-19 was 19,006, but for the 2015-2020 period, more than an estimated 120,000 cases of sexual offences against children were reported to the SAPS. So we clearly have got a major problem with the implementation of our legislation. And I think that I'm sure we all join in the sentiment that that is going to be a major issue that we as a portfolio committee will have to deal with. Thank you, Chair.
I will now give this opportunity for the presenters to respond to the questions posed and note the comments made. Over to you. I think it's before you respond, I think it's important. There's an issue raised by Honorable New Vote Dragons, which I think it's important for the purposes of us when we have the discussions. I think it would be important that you leave the slides so that we can have access.
The slides, I think the slides are forwarded. Thank you. The issue of age, we are saying in all bills, not only on that particular one, that the definition and the age has been defined to be 18 years, the age of a child. That is the specific that we are dealing with. And then I am not sure, Toli, whether you want to add anything into that.
Yes, colleague. In addition, what I was speaking to in relation to age is that the bill speaks to people who are vulnerable in institutions of higher learning and deems them to be at, when you're under the age of 25, then you're more you deserve to be protected, as opposed to a person who's over the age of 25 and at an institution of a higher learning. A person who's attending a higher education institution still experiences vulnerability, whether they're under the age of 25 or over. It must therefore be taken into consideration that age can't be the sole determining factor in relation to vulnerability, in relation to sexual violence. Hence, we have high rates of older women who are violated in terms of sexual offences. So what we are then proposing is that the provision must not be included, because then what it seeks to do is that it seeks to exclude individuals who are over the age of 25 in institutions of higher learning, who unfortunately are facing the same challenges and risks as younger students in these institutions of higher learning. That is our actual proposal.
Thank you.
Thank you, Chair. Sandra, do you want to comment?
Yes, good day, honorable members of this committee. I would like challenges that are faced in respect of gender-based violence. I think whilst I'm answering this question, I'll also touch on what I hope I do answer that. I think the implementation of these legislation, and I'm speaking from a legal practitioner's standpoint, is that we do have good legislation. However, when we have to implement it on the ground, barriers like financial issues need to be linked up with that. We cannot have good legislation and without a budget that follows that legislation, firstly. So that would mean that we need to interlink with the Minister of Finance and have a budget allocated to the implementation of these programs of legislation. An example would be what happened in New Zealand when they implemented the victim support legislation, where they stated that they had allocated approximately 42 million for a period of 3 years to ensure that implementation occurs, and then you come back and you take further steps. So training of police officers would happen in conjunction between the women's department. So that is that aspect that I'm talking to. I think we as South Africans are fully aware that femicide and gender-based violence has become a huge issue in South Africa. To ensure that gender-based violence comes down. However, I would like to note to our members that, honorable members, that it is not merely the role of legislation to reduce the numbers that we are facing. It is not merely the role of one particular political organization to reduce aspects. It takes a community, and we need to understand that we've inherited certain violent tendencies that we have not yet as a nation addressed. The history of apartheid is a very violent narrative that we need to discuss. Research needs to be taken to have discussions about it. And unfortunately, if you look, we don't have sufficient research. So I think that part needs to come in where we stop drawing ourselves on political spaces of the budget. So the most vulnerable communities in rural areas need the most amount of support to of a partial court system. So that is what we are saying as the ANC Women's League. I hope I have answered honorable members Swart's question, as well as given guidance with why it took so long for the ANC Women's League to step up. But we have been in the forefront of fighting against gender-based violence. We have been taking small steps, which I think the ANC Women's League is on the ground. Thank you.
Thank you very much. I think one of the issues that we would, I think the department is also listening. One of the issues we would be very much interested on it's when by the time we finish the bill, would want budgets attached to the implementation of these bills, because even when we have to present bills to cabinet, we have to clearly indicate the financial implications. So as we want to see the budget attached to the implementation of these three bills. Thank you very much to the Women's League.
Say something. I just want to give it to Tuli to just say thank you on behalf of the ANC Women's League.
Okay.
In that 3 minutes.
Yes, okay.
Chairperson and the Portfolio Committee in general. I think mine, in conclusion, and to pull together this day's presentation, is to emphasize on the question of power in addition to the availability of budget. We are speaking of the question of power. And the question of power is really about the dominance of patriarchal attitudes. Is not a problem just of the script of the law, but it is also a problem of mindsets and the ways that we forward and implement these laws. And this means that the law is not on its own objective, but it's subject to a set of subjective interpretations. This means then that as we move forward, we must also take into consideration things such as the implementers of the law and their own subjective positions in the ways that they forward the struggle towards the end of gender-based violence. And this requires us to also look at the arms, the three arms of the state, and the relationship therein. And this means cabinet, parliament, and the judiciary. The ways that these three arms relate to each other is also going to determine the ways in institutions of the state and of society. Thank you very much.
Thank you very much. Thank you very much. Now, thank you very much to the Women's League. We will now move to the next presenter. That is the Children's Institute.
Good morning. I am here.
You can start, ma'am.
Good morning, Honourable Chair and Honourable members of the committee, for inviting the Children's Institute to do our presentation to you this morning. I'm going to share the presentation, and I'll start off our presentation and share it with Lucy Jamison, who is a senior researcher also at the Children's Institute. I just want to, okay. Just would like to introduce you to the Children's Institute. We're a multidisciplinary unit located within the Faculty of Health Sciences at the University of Cape Town, and our aim is to contribute to laws and policies and intervention that promote equality and realize rights and improve conditions of all children in South Africa. And one of the CI's research focal areas is prevention of violence and research based to inform our presentation this morning. I'm the director of the Children's Institute, as well as a professor in the Faculty of Health Sciences at the university. I have more than 30 years of experience of working both within the children's and women's sector, with civil society organizations, as an academic, as well as having worked as a technical advisor to government programs, to programs on violence against women and children. I also led the determinant study on violence against women and children for the Interministerial Committee on the Root Causes of Violence Against Women and Children. I've also done extensive work and led 2 national studies on femicide in South Africa, and therefore want to draw on some of my research experience this morning to present this to the committee in terms of how we have shaped our input on the legislation. What we're going to do this morning is, firstly, I want to highlight the deep links between violence against women and children, and based on this, the Domestic Violence Amendment Bill, as well as to the Sexual Offences Related Matters amendments. I will take the first part of the presentation and then hand over to my colleague, Lucy Jamison. So if we're thinking about violence against women and violence against children in South Africa, we see that in South Africa, and we know research is telling us that about 1 in 2 women have experienced, if 45%, often becomes really important that we understand that these 2 problems co-occur within the same household. Not only do they co-occur, but they have shared similar risk factors with underlying social norms that are common to both problems. So children coming from violent households, research are showing us they're also at greater risk of experiencing violence. We've certainly got to think about how we reduce perpetration early on. And therefore, what we do see is that violence against women and violence against children mutually reinforce one another. Children in households where mothers are abused, research is also showing violent men who have killed an intimate partner has shown that, and I'm just sharing this quote, that when children experience violence in the home, and this is men who have killed intimate partners, it certainly impacts on their feelings of safety, it exacerbates their feelings of powerlessness, and repeated painful experiences become internalized and affect later interest. The common risk factors that we do see for violence against women and children is certainly it's underpinned by gender inequality that drives power dynamics between adults and children, and it creates the possibility for violence to occur. Male dominance certainly underpins and drives the behavior for violence in the home. We also know that partner conflict, so when there's partner conflict in the household, that's associated with intimate partner violence, it increases the risk for children to experience all forms of violence. Importantly, harmful use of alcohol and drugs within the household is also associated with increased risk for IPV perpetration as well as violence against children. The determinant study that was conducted on data for from South Africa certainly shows us that there is direct pathways between conflict around household income, conflict in the household, and then in experiences of both physical and emotional abuse by children. What I'm not showing to you here today is that there is also direct relationships between victimization as adults as well as perpetration for men and for women to become victims. So therefore, what we are seeing is consequences on children's health, well-being, and development. Violent discipline and exposure to intimate partner violence against women in childhood have been shown to increase the likelihood of violence during adulthood, either as victims or perpetrators. Men who experience violence in childhood, including corporal punishment, are more likely to become perpetrators of intimate partner violence, and therefore men exposed to childhood traumas are at increased risk for IPV perpetration, and all particularly. So therefore, the recommendations that we are proposing is based on our solid evidence that we have generated from our research. And firstly, in terms of definitions, we're clearly saying that corporal punishment should be included in the definition of domestic violence. It's not good enough to just have physical abuse, because I think the linkages between corporal punishment and intimate partner violence and domestic violence is incredibly clear. Children's exposure to the intergenerational effects thereof, and therefore we need to be urgently addressing the need for therapeutic support, as well as integrate into our definitions that it should include other related persons as well, because in the home it's not just they should not be deleted from the act, where stalking is part of an act and it increases the risk for femicide to occur. And if we're wanting to reduce numbers of femicide, we've got to acknowledge that stalking is an important part of intimate partner violence, and if we delete it, it shows failure to acknowledge the act as a form of domestic violence. Children in shelter, when children are not removed from the family environment, and therefore the Children's Act still governs and has strict regulations that we need to be taking into account. And therefore harmonization between the Domestic Violence Act and the Children's Act that allows for is important. In addition, what we're calling for also is that we have to start thinking about the Children's Act, instead of removing women and children from households and allowing men to remain in their comfortable spaces. We're also calling for providing access to appropriate therapeutic services for both women and children when they enter shelters. We know this is a really important time for children as well as caregivers to work through the trauma they've been experiencing. We also therefore promote the removal of offenders in the best interest of children. The other issues I want to raise is firstly that seizure of dangerous weapons is welcome, but I think the important thing is that firearm licenses, we should be thinking of how we suspend and not just remove in the situation. And why I'm saying this is that my work on femicide has shown us that ownership or having a gun in the home increases the legal gunshot, and therefore suspending gun licenses are really important. Sentencing and harsh, stricter sentencing from research is showing us that it doesn't act as a deterrent to domestic violence necessarily. We are calling for a functional criminal justice system where we successfully prosecute cases and serve the needs of community. And it's really, really critical to get justice, and this is critical. Training has also been highlighted by the previous speakers, and it's really critical that we think of training within the Domestic Violence Act and make it mandatory for police and magistrates, but that we consider how training is done. It's not just about understanding legislation, but that training becomes gender transformative, and it deals with the gender norms that underpin the high levels of both violence against women and violence against children within South Africa. It needs to emphasize an intersectional approach that looks at power dynamics and that highlights the needs of marginalized groupings and is victim-centered. Importantly for us, we're also calling for a central surveillance system, it's not enough to be collecting data. We've got to be able to link our data sources, and the Honourable Swartz had, spoken about the fact that our sexual offences, in terms of what the police have recorded and what department, we can be able to track cases through our system between departments. This will improve monitoring, and it can be used in order to plan services. And I'd like to hand over to my colleague Lucy Jamison at this point. Over to you, Lucy.
Good morning, everyone. My name is Lucy Jamison. I'm a senior researcher at the Children's Institute, where my research focuses on violence against children, the child protection, and I also teach child rights and child law in the faculty. The effectiveness of the National Child Protection Register and the National Register for Sex Offences. This is something that many of us in the children's sector have been campaigning, a critical component of children's right to be protected from violence, and that the aim of protecting children and now this broader group of vulnerable people from coming into contact with sex offenders by blocking employment to that group is an aim that should be commended. However, we have been monitoring the effectiveness of the register. And the first point to say is that we really don't think that this is the best way to protect children. In the first instance, the register doesn't include everyone who poses a risk. The figure that Honourable Swartz mentioned earlier is validating all of the names that are on the register. So it's our interpretation that that figure is for all of the years since 2009. And, at the same time, we see on average 20,000 reports of sexual offences against children alone, not to mention women and other vulnerable groups. So we're really concerned that it's not capturing everyone who poses a risk, even if it were working optimally. The second thing is that from the perspective of looking at how it's designed, it's not comprehensive. So not all crimes against children are held on the sex offences register. There is, in addition to the sex offences register, the National Child Protection Register, but there are other crimes that are held on neither. So, for example, you wouldn't want a teacher who has a criminal record of physically but not sexually assaulting children to be employed in schools. So schools have to have been physically violent towards women. We would want to scrutinise those crimes when a person is being employed. Other crimes such as driving under the influence. We don't want drivers in schools or child and youth care centres to be employed if they have those offences on their records. And from a practical point, for small CBOs who are offering services to children, it's cumbersome and confusing to have to screen against both of these registers. Next slide, please. Next slide, please.
I'm seeming to have a problem. I can't move the slides. Can I ask the yeah, thanks.
Of the Portfolio Committee for Justice and the Committee for Social Development, that a better alternative is to require criminal records checks. We believe that that is a route that would offer a more comprehensive safety net, because all violent crimes, not just those committed against vulnerable groups, are recorded. It also, as previously mentioned, includes crimes that would render individuals unsuitable to work with children, such as driving under the influence. The the actual effectiveness, the implementation of the register has been questioned. And we think that using just the one system, the criminal record system, would ensure that limited resources are pooled into ensuring that we have one effective system rather than many and multiple semi-functioning systems. Slide, please. So the criminal justice system has a role to play in protecting children from further harm, but also to fulfill that right in ensuring that children receive the support and treatment that they need so as to restore them to full physical and psychological health. And we believe strongly that there should be clear obligations on the state in the Criminal Procedure Act and the Sexual Offences Act to ensure that child victims and witnesses receive appropriate support through therapeutic services, counselling, court preparation, so that we can ensure that children are protected from secondary trauma, but also that we get good case outcomes. Next slide, please. And finally, from a child rights perspective, we have to remember that children have different rights to adults. Importance. They also have a right to special protection within the criminal justice system. And not only do children have these additional rights, but it's very clear from the evidence that children have a greater potential for rehabilitation and reintegration into society. So given these two factors, we think that the committee needs to be mindful that the legislation has to adopt a different approach when it comes to child offenders. And there are two critical areas where we think that that needs to be applied. One is in relation to how long a child's name will remain on those registers, and the current proposals would have would see a doubling of the amendments to Section 42 of the Act allow for the publication of details of every person whose particulars have been included in the register of sex offences. And we believe that that should not apply to child offenders or to people who have committed offences when they were children. It's not in the best interest of the child to have those details made public. And that's it from us. I'd like to thank you very much for the opportunity to make these presentations. We wish you luck with your deliberations, and we are happy to answer questions. Thank you very much.
You are muted, Chair. You are muted.
Thank you very much, Honorable Janche. Honorable members, do you have any questions for clarity seeking? I think there were...
And Honorable Wilmer, it's on the chat.
Honorable Nibot Drachens, in that order.
No, thank you very much, Chair, and thanks to the presenters. Correct, Chair. It's quite straightforward and clear that I just need two clarities because you can introduce laws all the time. There are critical issues that we must switch on and attend to, and they've highlighted one of those, which is the issue of, they call it that we need to attend more on functional justice system. That issue has just to get from them. Firstly, important is that issue is what is it that they have identified that has moved them and made them to conclude that we've got challenges of a functional justice system. And secondly, what is it exactly they are proposing. It could be a number of things, but I'm looking for one or two things they're proposing that will improve on a functional justice system. And the second area, they've highlighted on the issue of capacity building or training. They have highlighted the issue of training police officers and magistrates. I'm more interested in the magistrates. As you know, Chair, that's my area I'm closer to. And again, the issue I'm asking, because they have not really elaborated on that, you're thinking of training in relation to magistrate. It's not enough for me to just say issues of gender transformation and all of that. What have you picked up that made you to conclude that there's a weakness in the training in the magistrate, and therefore they need training? Because we would like to pick up those issues. So what are you highlighting as the training needs in that space? Thank you very much, Chair.
And thank you to the presenters from the Children's Institute. Apologies for the delay, there's just a network problem.
I'm fine, Delphin, I can voice.
Go ahead.
Okay, just tell Wilma.
Can the host remove the spotlight on the interpreter, please, and put it on Honorable Wilma? Remove the spotlight from the interpreter.
Okay, sorry, Chair, technical difficulties. Thank you, Chair. Thank you to the Children's Institute for the presentation. So thank you for that presentation. During the lockdown, I had a very big concern during lockdown that children and the women that have to run, and it's always them. So when the abusers and the perpetrators, they get to experience in the shelters, we don't even know if it's safe for them there with regards to coronavirus. So disrupting the children's lives when they have to go to shelters. I want to know, in the law, any of the three laws, should there be something included that the perpetrators and the abusers leave the homes instead of the children and the women, so that they can stay safe in the home environment? My second question, I see nothing, maybe I missed it, I see nothing mentioned gets therapy. There should be something in the law with regard to that. I don't see it mentioned anywhere in the presentations either. Then gun violence. Gun violence is on the increase. And you mentioned the guns and that the licenses need to be taken away. But I want to ask, in the law, whether that person has a gun or not, and then immediately do that investigation, and then also check whether that license or that gun is legal if they have a license. So that for the first time, when they come in front of the court, the gun gets taken away. We cannot preempt where the femicide is going to happen. It's also on the increase. So we need to do that right from the start. Then you said the ending that those be combined into one, and SAPS has all the crimes that are committed. So it's not only sexual offences, but all the crimes. But now my question is, right now we know that SAPS is overburdened with a lot of work and very limited resources. Now, does the Child Institute recommend that that register be held by SAPS or under Justice, the Justice Department, who needs in Malmesbury? And I'm talking about the language of children. You, as a speaker, in your experience with children for many years, you are aware that children and disabled children specifically sometimes don't have the language to explain what happened to them, right? So now, because children do not provide enough evidence the prosecutor throws out the case or doesn't bring the case before the court, children, it's the same with deaf children and mentally disabled children. They don't have the language capability to explain what happened. But how can we prevent the cases from being thrown out of court so that the children can provide enough evidence, even with the limited language? 3 laws, can we strengthen that? That's it from my side. Thank you, Chair.
Thank you very much, Honorable Nivot Drachens. Over to you, presenters.
I'm here, Chair. My hand is up.
Oh, okay. Honorable Mufuke.
Thank you very much, Chair, and thanks for the presentation. I just wanted clarity. I've been covered by Honorable Velma on the issue of the register. The question is Valid Records Act, and maybe to clarify on that, because I thought that the register will be doing a lot of work, but also I saw somewhere where you are saying that the children have no interest to be in the register. I don't think when they are going to be registering on people that are actually found guilty on that, the children's names will come out. I don't know. I don't think it will happen, but that we agree that the children should be protected. I want to check on the other issue that you never raised. Everyone is raising the issue of the teachers should be checked, the employers and all that, those that are working with. We should be having actually something that will say about the Bob Hewitt case can be a lesson in this country, that as we send our children to do sports and other things that people don't think about, things do happen there. And the other thing is also on the issue of the drivers of children to schools. I learned recently that some girls, they are now teenagers, are talking about their life with a driver when they were actually taken to school. And that is something that parents never actually thought it's happening. The other day, this person drops the other one first, and then the last one is a target. So we should be saying, what about the same checking and all that? I do respect the Children Institute because you are the custodian of the children's right. But we need to also say to you, let us say that on things that are happening, we want to propose this to Parliament. And that will work for us because for now, the challenge, thank you for your presentation. Thank you.
Thank you.
Shall I go first and then hand over to Lucy? So the Honourable Deanti had asked about a functional criminal justice system. So in terms of children, and I'm particularly going to focus on children, I heard us that very few cases, particularly sexual abuse as well as physical abuse of children, go through the criminal courts. And as one of the previous I think it was Honourable Nivot had indicated that, you know, the children often lack the capacity and they're not articulate enough, depending on their developmental stage, to tell us exactly what had happened. And it doesn't get through to prosecution stage. Prosecutors act as gatekeepers to determine which cases go to court. What then happens is that and what we are saying, and therefore we should be thinking about how we improve our system to allow for and acknowledging that there is, depending on how old the child is, there will be a developmental capacity in our criminal justice system. Because what we are seeing is that, in fact, perpetrators are getting away with acts that should be criminal, that they should be convicted for. And that will go a long way to other children then being victimized. Lucy, I want to hand over to you as well to talk about the capacity building and training.
Whereas extremely young children may not have the capacity to communicate what's happened to them. A number of children are excluded from the process and cases are thrown out because actually it's the prosecutors and the magistrates who don't have the capacity to listen to children. So Honourable Nico Druchen was talking about deaf children, actually justice system. And that's where training is essential in terms of understanding the developmental stages that children going through, understanding their capacities, and ensuring that we are creating a safe and enabling environment for them to be able to participate either as the victims or survivors or witnesses to crimes. So the other thing in relation to that about the training is that I conducted a child abuse tracking study back in 2017, and we monitored what happened after children had reported abuse of different natures. And one of the things that we found in relation to that was that the law is not applied properly and consistently. So Honourable Gianti talked about a functional justice system. I'll give you one example from, so we had a case where an adolescent, a 14-year-old, had been, her mother had arranged for this child to have sex with a neighbour, and the mother was financially compensated because the child was having sex with the neighbour. The child was repeatedly raped by this man over a course of several months. The evidence was clear of the violence, was sentenced to community service. There was no custodial sentence, despite the law saying that he should have gone to prison for several decades. He was within a period of 5 years. Now, that is one example where the law is not applied and the justice system is not functional. It's not a problem with the law, it's a problem with the implementation of the law. So training is not just about sensitivity. It's not just about the capacity and understanding children's development. It's also training in the basics of how to apply and interpret the criminal justice issues. One is about the registers. The police have already a comprehensive database and records of crimes that have been committed. There is no need to create a new register. We are suggesting, and let me be clear about this, we don't think that the sexual offences register or the child protection register are adding value. We should be building the capacity and investing in one of these registers. And we believe the best register to invest in is the criminal records database that's held by SAPS. And then the final point that I want to address is the removal of perpetrators. And yes, we do think there should be some provision in here that is either similar to Section 153 of the Children's Act or a cross-reference, which enables that the perpetrator is removed from the family home rather than women and children having to remove themselves and seek refuge and safety somewhere else. How that is done, as I said, could either be with a cross-reference to the Children's Act, but then it's only specific to crimes against children. Obviously, we would like to see women having the same kind of protection. And that's me. Thank you very much.
I'll invite the Congress of South African Trade Unions.
Hi, good morning, Comrade Chair. Can you hear me?
Yes, we can hear you.
Of course, thanks. I think, Comrade Chair, I would ask me or one of the colleagues from the committees to assist with just sharing our presentation if that's possible. I'm always wary of crashing the IT systems in this new normal. But yeah, I think if you
Okay.
could do that.
It gets
Okay.
bad if you have somebody who's marching into the system. It does that.
Yeah, I'm afraid, Honorable Yankee, I crashed the system once. I'm very afraid of crashing the legislative arm of the state and disrupting our members of parliament.
Okay.
But I can proceed so long if Vonani is able to share, and I can proceed so long and can catch up if you want.
Due to flight your slides.
Okay. All right, then let me start, Comrade Chair. So yes, look, thank you for giving COSATU space to share our views on these three critical bills, Chairperson and members. Good morning. My name is Matthew Parks. So I'm here on behalf of the Congress of South African Trade Unions. And I think, Chair, yeah, okay, I can see the slides. Thanks, Vonani. So I think, Chairperson, for us as COSATU, our premise is one is that we have a pandemic of gender-based violence against women and children and other vulnerable persons. In fact, it's a stain against us as a country to resolve it. So I think, Chairperson, for us, we support the bills. We welcome them. We recognize they come out of the commitment by the President. Just go back to the previous slide, slide number 2, in August last year. So for us, Chairperson, our philosophical stance is that we need a bold, decisive, and harsh interventions. We believe these bills are a step in the right direction. And look, some of the issues in the bills you could say raise constitutional issues, and we think that's right. We think for too long we've been erring on the side of the rights of the perpetrators and often undermining the rights of the survivors of gender-based violence. So I think these bills are a step in the right direction. There are, of course, additional government society doesn't embrace the spirit of the laws, then these laws will remain as on a piece of paper. And there's a responsibility of all of us, because when we go home, so we have an ultimate responsibility. Next slide. So, Chair, our position as COSATU on the three bills is one, we defend the bills and see how they can be strengthened, and of course, how they can be fast-tracked. We would not want to see bills in any way being watered down. It takes years to get bills through, and so we don't want to waste this opportunity. Next slide. So, Chair, on the first bill, the criminal law, the sexual offences and related matters bill, there are many areas that we support in it. They are quite welcome updates, and I think we welcome the definitions of vulnerable persons. Next slide. Yes, we think this is a welcome overhauling of the register. We support the inclusion of all sex offenders. We shouldn't be limited only to those who abuse children, but all sex offenders. Infringing on the rights of the requiring persons who apply for jobs to declare if they've been convicted of sexual offences, as well as the restrictions on certain types of employment for convicted offenders. We think, Chairperson, again, this is a restriction on the rights, but again, who must we choose? Must we choose the victims or the perpetrators? And we must always choose the victims and the survivors. But of course, Chair, that the definitions of the types of employment, we think there would need to be engagement with society. And that obviously would be done through regulations, but we welcome that being fast-tracked and would contribute ourselves, and we'll support as COSATU. For example, that you couldn't have someone convicted of rape being a teacher or being a police officer, being a prison warden, etc. Chairperson. Next slide. Chair, so we have a few proposed amendments. So Section 18 of the Sexual Offences Bill requires that persons must report suspected offences that may have been committed against children or persons with mental disabilities. So we know this is a contentious issue. I think philosophically it's a correct provision. It's my obligation to report it. It shouldn't be an if or all. But of course, Chairperson, there are always possible risks and possible unintended consequences that I think we need to discuss a little bit and see how can we maybe further strengthen this clause to prevent any unintended consequence. I think the one issue, Chairperson, is that what happens to, I report my neighbor for abusing his wife. What happens to that woman? Will the husband come interventions which may not fall in a bill, but may be more administrative or programmatic to give support to those persons? Because obviously there's a power relationship between the man and the woman often. What happens to the father who abuses a child, and what happens to the child? Where will the child go, for example? But I don't think we must cut the provision, Chair. I think it's about what are the safety mechanisms we can look at supporting it. I think the other issue around the provision, Chairperson, if I read it correctly, the requirement is to report offences committed against children and persons with mental disability, for offences committed against women or persons who are vulnerable. Surely it's a principled issue, it's a moral issue. And again, I think we should look at including that provision as well, Chairperson. But again, to see what are the safety mechanisms for the victims who might become secondary victims or double victims, so to speak. But we would want to see that clause being retained, Chairperson. We wouldn't want to see it be removed as the correct clause, but just how can we further state. Chair, other parts of the bill that we support are the provision for court intermediaries for the complainants. That's a welcome provision, especially for children or persons with mental disabilities. I think we'd also welcome the provision for audiovisual links. These are critical, especially for vulnerable persons. Next slide. Chair, we support the tightening over the harshest possible conditions on all three fronts. But I think this is a welcome intervention in the right direction, Chairperson. We think far too often the courts and the police have been very blasé about these conditions. But our one concern, Chairperson, is that we can have these provisions in law, but we've seen time and again magistrates simply choosing to ignore the law. They would want to cry about their powers to make decisions, etc. And again, the victims are the ones left paying the price. So we support the provisions of the bill, but there would need to be work done by SAPS and by the courts to make sure that the bill, we welcome the tightening of protection orders, including the confiscating weapons from suspects. We support the obligations for the departments of social development and health, police, etc., to provide support. But I think we would need to engage in the regulations and what does that mean in simple, practical steps. I think often those departments are not fully played the role they are meant to play. They've often, Chair, we welcome the electronic servicing of notices, electronic databases. This is a useful modernization process. Next slide. Chair, I think also we're quite pleased to see the provisions in the domestic violence bill empowering the police to arrest without warrants if they believe there's cause, and equally to enter premises without warrants if they believe there's cause. We don't need to err on the side of the perpetrators, but to continuously err on the side of the complainants and the victims. Next slide. Chair, we've got some proposed amendments for the domestic violence amendment bill. The issue of sexual harassment provisions. So we support the sexual harassment provisions. They're useful, they're fine. But I think as some other colleagues have already mentioned, we should reinsert the existing stalking provisions provided for in the Act. We think stalking provisions are not necessarily covered by the sexual harassment provisions. They complement each other, but they're not necessarily the one and the same. But the stalking provisions provided for under the Domestic Violence Act basically define what is to reinforce, then to inadvertently omit a useful provision, Chairperson. Next slide. Chair, the other proposed amendments around the domestic violence bill is that on page 7, section 2K, under harassment, it says harassment means directly or indirectly engaging in conduct that the respondent knows or ought to know. It's that unwelcome sexual attention from a person in a domestic relationship with the complainant who knows or ought reasonably to know that such attention is unwelcome. Yeah, so next slide. So Chair, our concern is basically twofold. One, we believe that when you use words that the respondent knows or ought to know or should have reasonably known, you may create a burden for victims to prove the perpetrator ought to have known the behavior was wrong. It shouldn't be for the perpetrator, so for the victim to have to prove. We are all adults, Chairperson. We should all know the rights of citizens, the rule of the law. We should not be requiring the victim to prove that the accused knew or ought to have known. The law is the law, Chairperson. The other one, Chair, is that we have a society where there's a large prevalent impact of the perpetrator's behavior on the victim, regardless of whether or not the accused knew this behavior to be wrong. The next slide. So Chair, our proposal here basically was simply on both clauses to delete the words knows or ought to know from section 2K, and on section 2RA, again to delete the wording ought reasonably to know. Next slide. Chair, on the domestic violence amendment bill, on which says a reasonable person having regard to the circumstances would have anticipated that the complainant would be offended, intimidated, or humiliated. We're not sure what does a reasonable person mean, and if we leave such wording, which is quite ambiguous, it could create unintended consequences. So I think reasonable might need to be tightened or clarified, Chairperson. Next slide. So, Chair, in conclusion, as COSATU, we support the 3 GBV bills. These are welcome interventions by government. We think we need to further strengthen the bills and to adopt our proposed amendments and probably some of those of colleagues to address some of the weaknesses. But in principle, we should defend the bills. We should see the urgent passage. Colleagues might be aware that at the International Labour Organization conference in Geneva in June last year, South Africa supported the Convention 190 on sexual harassment at the workplace. That Convention 190 needs to be tabled at Parliament for urgent ratification. It's been sitting with the Department of Labour for 18 months. This is even after the Department of State, the State Law Advisors had certified it a year ago. But secondly, Chair, I think there would be a need to a further review of criminal labour laws to make sure we've adequately covered the commitments of Convention 190. Then the last slide, Chairperson. I think, Chair, the last slide really is about the funding we provide for our commitments on law. Victims depend upon legal aid frequently, yet Treasury is cutting the funding allocated to legal aid. So that's a contradiction. That's something we should stop, because legal aid has to be priority, especially for women and other victims. Chair, we need to, stating the obvious, to resource and train our courts, our police, our health and social development, and our education officials. Too often you'll find they simply have no knowledge of the laws and the provisions, and this costs victims. But lastly, Chairperson, is about empowering vulnerable persons in society at large to know what are the provisions in the law, and of course, thank members for giving us space. We hope we've assisted colleagues. Thank you, Chairperson.
Thank you very much, COSATU. Honorable members, do you have questions?
Yes, Chair.
COSATU? Yes.
Yes, Chair.
I have on my screen Honorable Mfukeng. Yes, I have Honorable Janji. I have Honorable Yako. In that order, anyone that I have not seen would indicate, or I also have Honorable Nomathemba Maseko Jele. So it's Honorable Mfukeng, Honorable Janji, Honorable Yako, Honorable Maseko Jele, in that order.
Thank you very much, Chairperson, and thanks for the presentation from COSATU.
Honorable Mfukeng.
Presentation, Mr. Matthew. I just want to, actually, I'm very excited that if COSATU is the one that feels that we must defend the bills, it's highly welcomed. I want to check that on the side of COSATU, are you going to defend it in a way that you will introduce education at workplaces? Because we know that the patriarchal tendencies are still there in education. Are you going to be looking at the harassment that you are talking about, especially sexual harassment, we say tightening of the parole conditions? Are you happy with the parole system that we are having now? And then are you happy that we are going to tighten the protection orders? What is it that you saw that was lacking in the protection orders so that implementation can be better? Thank you very much.
Thank you very much.
I just want to check with the Federation of the Workers, COSATU, and I want to ask something that they did not say here, and I need to raise this with them deliberately. And the issue here, Mr. Parks, is the issue of patriarchy and the law, and patriarchy and civil society, the role of civil society. We are lawmakers. It is our role to do what we are doing, because the law is very, very important, as you have listened this morning from the Women's League, and this is something that you know. And yet I didn't hear anything from that. that it's possible that we can have all of these laws and yet we remain with these challenges, Matthew Parks. And I'm wanting to challenge you because the issue here, beyond the laws that we're going to we're going to note and ensure that they happen, um, what is the role? What is that gap? What is lacking? And I was hoping that you'll get into that. What is lacking that is not necessarily going to be addressed by these laws or even issues of resources and finances? Because you get somebody, let me give you the Winene Mkhojana case, which was a very pacey one. Get somebody arrested, um, charged, taken to court, and convicted. A week thereafter, you have got a similar situation of another woman murdered with the same modus operandi. So clearly the issue is as a key player in civil society. What is it that as lawmakers we're missing that must be done to reinforce the laws that we're putting in place, because on their own, they are not working, Matthew Parks? What is being missed? And you've been very eloquently silent on that issue. Thank you.
Being eloquently silent, I will now know.
Thank you, Chair. I'm watching Kosat.
Honorable Yago.
Thank you very much, Chairperson. I think I'll probably reiterate the previous speaker's point in a different way, however, with a lot of unions sometimes using strike action, amend the laws, whatever it is that we do, but the police do not play their role as they are supposed to. And my question to COSATU is, are you willing to put your bodies on the line to make sure that gender-based violence is at the forefront of this? We are willing to put our bodies on the line. We are willing to use our members to make sure that we go to where the calf has basically, to make sure that we fight this head on. It is not enough to just say the words. It's not enough to say the different vulnerable groups and name them. However, you have to put your bodies on the line and you have to be action orientated around gender-based violence. Thank you, Chair.
And also thank you to COSATU presenter, Mr. Matthew Parks. But you said a statement which really sparked me, or making me thinking about the magistrate ignoring the law, because most of the problems that we have sometimes we do pick something like that befitting when it comes to such perpetrators of violence of GBV. So I'm sure that one, my colleagues who are in that area and ourselves will also look into that one, because it's very serious. This is very serious. We must make sure that we, and then also on the issue of training, officials that are involved in assisting us in this matter. Sometimes it comes, in fact, I think that these police that are responsible for sometimes returning people women when they come and report at the police station, I sometimes, without, with due respect, I sometimes think some of them, they are also perpetrators. It's just that they have not yet been caught, because I don't think that you can take some or the other. I think in going forward, we'll have to look into the people that you are assigning to such serious responsibilities like these ones, because we want people now to specialize, to group people and say, these are the people that are going to assist us in this, and we train them and we make sure that they are equipped with the proposal. The bill proposed that on the issue of the register, and also checking of the perpetrators when you employ them. It only, with correction, it only places an obligation upon the employer and the employee. This one must check the person that is your employee, and the employee also must disclose if maybe there is anything that has to do with. But in a case, if the employer ignores that and employ this person, and in the long run something happens, and when we check, we find that this person is a repeater of this offense. He has done something like this before, and the employer did not do the job. What is your view on that one? What can be done? Do we have to put something in line with that in terms of the punishment or whatever? Thank you, Chairman.
Jele, I'm not seeing any other hand. I think it would also be investigated for giving inappropriate sentences in as far as issues of abuse of children are concerned. And as Parliament, we have already supported her suspension. I think it's something that I thought honorable judges from the Magistrate Commission would have raised, that we take it very, very seriously, that all stakeholders should play their part. So there is the case that has served before us, and we have supported the suspension of that magistrate pending a disciplinary hearing. Over to you, Comrade Matthew Parks.
No, thanks. Basically on the same page, irrespective of the color of our t-shirts, political differences, etc. That's the only way we're going to reach it. It is eloquent. But I'll come to an eloquent question in a sec, which is the correct question. Question I myself always throw at my colleagues, that it's one thing to make demands. What is our contribution? So I think, Chair, to Honourable Mofokeng, look, we welcome these bills. I mean, the pandemic of GBV is so horrific. We know the bills are not a magic wand, but as long as they're taking us a step forward, Chairperson, and it takes very long to get bills moving. I mean, the fact of Parliament, it'll take probably a year to resource the government to implement it. But as long as we're moving forward, Chairperson, the areas to improve, sure, but I think for us to embrace the progressive spirit and the harshness of the bills. We've always been saying as COSATU, we want the law to be as harsh as possible, given the pandemic of crime that we're experiencing. And look, our members experience it because our members are mothers, they are daughters. Even if you're a man, you experience it. So I think, Chair, to Honourable Mofokeng, would agree 100%. We have to do a massive education campaign. Government can't do everything, so all of us. So as SATU, as POPCO, as NAHAU, we have to make sure our members are aware of the intricacies of the law, the technicalities, what is their specific responsibilities, but also even more importantly, Chair, to embrace it. So we have to really popularize it. I know it's been some years, Chairperson, that it really had mass education campaigns. I think, it's 26 years, we've long forgotten that spirit. So it really is about going door to door and to empowering people. I think we've really kind of allowed all of us as activists to outsource our work to government, and you can't do it. Things for all of us, whether it's churches, it's mosques, it's schools, or as parents, to make sure people are aware of the rights and equally the responsibilities, Chair. Otherwise, the law will just remain a nice English wording on paper. To Honourable Mofokeng, on the parole and protection orders, look, I think for us, our starting point is that they must be as harsh and as draconian as possible. Too often we have been frustrated where you will see countless times where perpetrators are just simply, if it was up to us, we would simply remove all the bail options, full stop. But we accept the provisions in the law as a reasonable compromise. We think they'll take us as a step forward. We think the protection orders that deal with the violence, the interests of the victim, the history of the accused, that confiscate weapons, those are useful. I think the requirements for parole to consult with, we've seen departments don't educate the officials and they ignore the progressive laws. But I think for us, Chair, the provisions in the bill are reasonable and we accept and support them. To my good friend and brother, the eloquent Honorable Janki. I mean, Honorable Janki is 200% correct, chairpersons. The law is here, the reality is here. I'm sure if we were to go to Kailicha, people would not even know what we're talking about. We're speaking nice English words. We've been frustrated as COSATU. We pass progressive laws in Parliament. Government then takes a year, sometimes 2-3 years to enact the law. We've got bills which pass Parliament, Comrade Chair, like the PIC bill, which dealt with corruption. A few other bills around unemployment insurance, paternity leave. And government hasn't even signed them yet. The president hasn't signed them yet. It took us about 2 or 3 years to get the does to support these laws. And you find government just sits on its toes, does nothing. Then, of course, once they even just sign on the piece of paper, said, fine, thumbs up, we implement. They don't provide the resourcing. They don't provide the training. So it's a contradiction to say, yes, support the victims or the complainant, but then we're going to cut legal aid. There are other things we can cut in government, chairperson. We can cut the salaries of ministers by 25%. We can leave complainants who honestly are overwhelmingly African women and children who've got no money. But then the issue of the training, and the training given to our police officers, to our nurses, to our teachers, it's shockingly, it's pathetic, chairperson. But again, government can do so much. I think it's up to us as ordinary citizens to embrace the spirit. And of course, I think that political parties, trade unions have all got a role to popularize it, to make our contents, to change our culture as South Africans, in which we can see half a woman in the lifespan will be abused. That's not normal. So I think for us, we would like to see the examples of, for example, like China or Singapore. There will be consequences. But we are sick as a nation, chairperson. There was an accused in Mpumalanga who was charged with raping, I think, his 7-year-old daughters, a former threat to society. And that was not a first story about him. I recall there was a story when he was a member of parliament. And look, these demons are in all of us, chairperson. Trainings are not exempt from the issue of abusing women. These demons are in schools. So really it's about all of us, instances of abuse to the police or to teachers, etc. It is going to take hard work. In the past month, we've seen a little bit of green shoots that are starting to rebuild that law enforcement capacity. But until we start seeing people in orange overalls moving to Paulsmoor, to Drakensberg, we won't be convinced. And for a long time, Chair, there was a shocking report, I think this week, where this police colonel who had been involved in selling weapons to gangsters in Cape Town. I think he had an 18-year sentence, but I was told he was being released after 4 years. So I think, Chairperson, we have to really rebuild that capacity of the state. Chair, I think to Honorable Yako, no, Honorable Yako is right. All of us have to be willing to play our part and put on our bodies on the line, so to speak. We had a National Day of Action as COSATU, which enjoyed support from other federations in the country about 2 weeks ago. One of our demands there was about tackling gender-based violence, something that all of us as a nation have failed to do. But they can't just stop there. We have to do much more practical work. There's a specific role for Pop Group, for example, in the police service to play its role. Pop Group, for example, chairperson has also often been our leading affiliate, speaking on the issues of domestic violence, speaking on abuse. There's a role of SATU, the teachers union. And in fact, SATU's got a position, chairperson, that if you're accused of sexual abuse, they will not defend you in your hearing. You're on your own. It infringes upon the rights of a member, but which one do you choose, the victim or the perpetrator? And if you're choosing to be a teacher, it's not a job, it's a calling, it's a profession. And SATU, in fact, chairperson, when I engage with SATU, they support the provisions in the safe place when we drop our children at school. Chair, Honorable Maseko Jele, I mean, Chair, I think often it's been a continuous problem that magistrates ignore the progressive laws the country Parliament has passed. This has been there for time and again. We don't think they should be given a blank check. If you're accused of rape, there must be a strict sentence. It can't be up to the magistrate to say, well, maybe the accused was flirting with you. It must be black and white, Chairperson. I mean, I've seen for myself, Chairperson, how it takes a year at least to get a sexual offense through a court process. That you will appear 12 times and it gets postponed and postponed and postponed again. Often victims just simply give up. But it's worse, Chairperson, you're sitting in the court benches. The victim is there in the same benches as the accused. That can't be right, Chairperson. The accused must sit underneath in the court holding cells, in cages. You can't put a child or a woman, Chairperson. So really the courts have to play their part. Again, Chairperson, I think it comes to what training we give SAPS members, but I think in fairness to SAPS members, we're seeing many of them are extremely overworked. And as you become overworked, you start becoming immune to the brutality and things fall through the cracks. But I think also SAPS officers are frustrated that they charge, that they arrest people, and the courts release them. And then a week later, they arrest the same persons again. But I must also say, I've been shocked to see that even women SAPS members need to be trained. I've seen oftentimes even women SAPS members lack sensitivity on how to handle complainants and to give them the space and respect they deserve. And the register being capacitated, but it has to be resourced by government. We saw previously when it wasn't given resource and there was no one on the register, no one was watching to make sure it's being capacitated. I think what happens to an employer who ignores the restrictions, Chair, I think must be twofold. One is that that worker must be dismissed as per the provisions of the bill. It was very clear if the applicant doesn't disclose and the position he or she has applied for is a position of supervision over vulnerable persons, they must be dismissed, so that provision is there. But yes, Honorable Maseko Jali is right. There must be consequences to the employer. They must be punished. They must be fined, and as per the provisions of the bill, it must be dealt with. We have to send a message to society and about building a culture of abiding by the law. But I think, Chairperson, really the point for the register is to make it a living eyes and the ears of government on the ground. But yeah, let me stop there, Chairperson. Thanks to members for the questions. Thank you, Chair.
Thank you very much. Your T-shirt the same as those one of Honorable Yako. That is why maybe you agree today. Thank you very much. Thank you very much.
Van Rooyen, and I'm attached to the Division Legal and Policy Services. Chair, forgive me, we sent our presentation this morning. I hope that the Secretary of the Committee managed to get hold of it. We are not technologically advanced enough to put it on our screens ourselves. I would request the Secretary of the Committee to assist us in that.
They're trying to flight the slides. Can you start?
I'll do that. Thank you, Chair. Just to give you a little, and we are committed to the implementation of measures to assist victims of domestic violence. A number of legislative proposals contain justice and constitutional development in this regard. The presentation, as I indicated, will focus mainly on pertinent concerns in respect of the domestic legislation. Insofar as the Domestic Violence Amendment Bill, we are concerned about the ambit of certain proposals, undue pressure that causes a complainant to act in a certain manner against his or her will. However, it includes social isolation or neglect. But how will social isolation be determined? That is a concern for the police service. Furthermore, it appears that one of the primary aims of the bill is the alignment of the Domestic Violence Act with the Protection of Harassment Act to include related persons. The service has a lot of apply only to persons in an intimate relationship, but will actually extend the ambit of the Act beyond what is considered as a domestic relationship. For example, the extension of the ambit, both on the side of a complainant and the respondent, means that the domestic violence relationship is now wider than before. By extending the ambit of the Act to include, furthermore, sexual abuse extends to related persons, and the sexual abuse definition is wider than the definition contained or covered by the Criminal Law, Sexual Offences and Related Matters Amendment Act, as well as the provisions of the Children Act. I'm currently on slide 7, please. Thank you very much. Sexual harassment includes the unwelcome explicit or implicit behavior, suggestions towards the complainant or a related person that have the effect of offending, intimidating, or humiliating the complainant. The proposed definition requires that the complainant must reasonably be offended. This or present when the behavior or suggestion is made, as it may have been made to a related person will have to be offended. This means that this proposal actually highlights the dilemma of expanding the ambit of the Act beyond persons in a domestic relationship to include related persons. In this regard, the complainant may not even be aware of the sexual harassment, and yet it's a requirement that the complainant must be ridicule or insulting of a complainant's religious or spiritual beliefs. In addition, the using of religious texts or beliefs as a pretext to justify, minimize, or rationalize abusive behavior is also included in the definition. In South Africa, we have a wide spectrum of religious and spiritual beliefs who are practiced and tolerated. The fact that a person in a domestic relationship or the fact that persons in a domestic relationship differ on the religious beliefs should not be read sensitively or regard the comment as insulting. Once again, the subjective assessment of a comment made by a Clause 3 provides for the reporting obligation placed on numerous functionaries regarding or a member of an employee of an NGO will be required to have knowledge of the ambit of the Act. In other words, know exactly what constitutes domestic beyond persons in a domestic relationships. And where the persons involved does not fall within the ambit of the definition of a complainant. Furthermore, it's important to keep in mind that not every act of domestic violence constitutes an offense. The obligation will mean that matters must be reported to the police service, even if it does not fall within the ambit of the service, since it does not constitute an offense. If an incident does not constitute an offense, the only legal remedy available to the complainant will be to will, in a similar position as a police service, as a police official, only be able to inform the complainant that he or she may apply for a protection order. It is accordingly unclear what the purpose of the obligation to report an incident to the service will be where there's no offense that has been committed. This is even more puzzling in view of a proposed amendment of Section. Provision is also made in the proposed Section 2, capital A, that the relevant functionary must conduct a risk assessment to provide or refer the complainant for further services. The service is concerned about the potential threat that the reporting of domestic violence may have on the safety and immediate well-being of a complainant. It is difficult to predict the risk that may be triggered by the reporting of domestic violence. Furthermore, it appears that there is an apparent duplication of procedures to address the reporting of abuse, including the criminalization of a failure thereof. Similar provisions are already contained in the Criminal Law, Sexual Offences and Related Matters Amendment Act, the Children's Act, and the Older Persons Act. And it is therefore unclear why these procedures are duplicated to some extent in the proposed legislation as well. The proposed Section 2, capital B, provides that an adult person who fails to report knowledge of an act of domestic violence is guilty of an offence. Once again, not all acts of domestic violence constitute offences. Yet, a person may be guilty for failure to report conduct of a perpetrator that by itself does not constitute an offence, especially where the victim is not willing to report the matter to the police. This proposal has serious consequences. Domestic violence at its core is about power and control exerted by the perpetrator over the victim. The perpetrator over time breaks down the self-esteem and self-confidence of a victim to the extent that the victim starts to believe that he or she is not of any worth and cannot take a decision for himself or herself. This obligation emphasizes the loss of control by the victim and the belief that he or she is unable to take his or her own decisions and cannot control the situation or seek help. Furthermore, if police officials start to arrest grief-stricken family members and friends after the victim of domestic violence has been killed because they failed to report an incident or knowledge of domestic violence. Family members and colleagues who have in whom the victim has confided will face prosecution for the failure to report such information, which means that they will have to betray the trust of a victim and will hamper the effective support structures for various reasons, including financial dependency or access to their children. And the victim may actually deny that that she or he is a victim of domestic violence or may refuse assistance. The victim may feel more isolated and will hide the true nature of their relationship with the perpetrator. Persons who are assisting victims to take control over their lives, including personnel at shelters and NGOs, will face prosecution if they do not report domestic violence, even if confidential information was shared by victims. This provision places the duty to report domestic violence on an adult person. An adult person also includes a family member or a child who is older than 18 years and who still lives in the household where domestic violence is committed. So the consequences of this legal obligation will be far-reaching to the by peace officers, and we have serious concerns about the implications of these proposals. The proposed amendment of Section 3.1 will empower a peace officer, and keep in mind, every police official is a peace officer, to arrest any person without a warrant who the peace officer suspects of having committed an act of domestic violence which constitutes an offence in terms of any law. Any person is not limited to the respondent, and any person may be arrested for an act of domestic violence, even if that person is not in a domestic relationship with the victim. Any act of physical abuse, not limited to incidents where the victim and perpetrator are in a domestic relationship, may be regarded as domestic violence, simply because there may be a possibility that persons may, in view of a proposed expansion of the ambit of the Act, be related to domestic violence. If domestic violence requires a domestic relationship between the perpetrator and the victim, it is unclear how the ambit. Furthermore, clause 4 means that any person, sorry, Chair, according to the proposed section 3.2, a peace officer is obliged, take note, must arrest a person who is reasonably suspected of having committed an act of domestic violence where physical abuse is involved. Any defensive action taken by a victim aimed at protecting himself or herself against a physical attack may also constitute physical violence. For example, if a husband beats his wife and she pushes him away, that pushing of a perpetrator is also physical violence. This means that the victim may, in an attempt to protect himself or herself, apply physical force to the perpetrator. In such a case, according to the proposal, the victim will also have to be arrested. In fact, the police will have no choice but to arrest both parties. Consider the consequences of this provision. A victim who has already been traumatized by the incident will have to be detained in police custody until his or her appearance in court to apply for bail. Children who have been exposed to the trauma of domestic violence in their home will also be witness to the arrest of both their parents. Children will also be left without the care of a parent while both of them are detained in police cells. A victim who is supposed to be protected will have to endure the humiliation of arrest and detention in police custody until his or her first appearance in court, which may be after the weekend. And victims will actually be expected to remain passive and endure any physical attack out of fear for being arrested. Those provisions or the proposals are of serious concern to the police. Insofar as clause 7 is concerned, provision is made for an interim protection, or stating that an interim protection order will be of force and effect from the time of the existence and the content of the order have been brought to the attention of the respondent. Some proof is required that the respondent must know about the existence of an interim protection order. To enforce the order, a police official must be able to verify that the respondent was indeed aware thereof and knew that he or she failed to comply with the order. If a police official arrests a respondent and it appears that the order was not served correctly, the service will be liable for a civil claim and the arrest will be unlawful. Clause 12 provides for the amendment of Section 8 of the Act, which deals with warrants of arrest upon the issuing of an order, and it provides that the police official has a discretionary power to arrest the respondent for the contravention of a protection order. However, keep in mind that Clause 4, which I've already discussed, provides that in the case of physical violence, a peace officer is compelled and has no discretion but to arrest a respondent who is reasonably suspected of having committed an act of domestic violence. Now, we are sitting with two conflicting provisions. I'm currently on slide 19. When a protection order is contravened, the police is required to deal with, to consider certain factors. And yet, when it's a physical, an act of physical violence, it is unclear whether a member must still consider the factors set out in Section 8.5 before deciding whether to arrest or not, or whether we should apply the new Section 3.2 that compels the police official to arrest in those circumstances. Then, as far as the Criminal Law, Sexual Offences and Related Matters Amendment Act Amendment Bill is concerned, just a few observations, Chair. In terms of Clause 3, the offence of incest will be expanded to include acts of sexual violation between persons who may not lawfully marry each other on account of consanguinity, affinity, or an adoptive relationship, provided that one of the parties is a child. According to the proposal, the parties will be guilty of an offence despite their mutual consent. Now, if one considers the definition of sexual violation, it also includes the direct or indirect of the mouth of one person and the mouth of another person. In plain English, kissing constitutes a sexual violation. The consequence of this proposal will be that any person, grandparent or family member will be guilty of incest if he or she kisses a child family member on the mouth, including as a demonstration of love, greet the child, or in circumstances of a congratulatory or celebratory nature. In terms of the proposed Clause 5, that relates to the amendment of Section 41 of SORMA. A person whose name appears in the register may inter alia not be employed to work with a person who is vulnerable in any circumstances. This includes specifically working in a facility where victims of crime are cared for or sheltered. However, according to the definition of a person who is vulnerable, no restriction is placed on such an offender to work in other places where persons are also vulnerable. Consider, for example, a sex offender who may be allowed to work in a hospital where patients are vulnerable and cared for. Chair, thank you very much. That is the presentation by the South African Police Service. No, Chair, there's quite a number of proposals that we support and that were included as a result of our proposals. We have only focused on the provisions that we have concerns about.
Okay, no, thank you very much. I have the following members. I'm not sure whether Honorable Masego Jele, you did not lower your hand because it has always been Honorable Jele.
No,
Okay.
Chair. I think it's not now.
Okay, thank you very much. It's Honorable Horn, Honorable Swart, Honorable Mufukeng, Honorable Nivot Trachans. I think those are the members I have on my list.
Chairperson, comments and concerns we as a committee must take serious note of, and possibly in respect of those, we must also ask whether the police service, like with other institutions that come and participate in the public hearings, could also assist by supplementing their comments to suggest how the amendments should be amended in order to circumvent the dangers they have identified. And in this regard, one specifically thinks about the dangers they identified in respect of the arrest by the peace officer, where I can understand their argument that if you in defense also make yourself guilty of a violent act and there's an obligation on the peace officer to arrest all involved, that could defeat the whole purpose of the exercise. Similarly, with the proposed amendment to incest, where surely it cannot be ever our intention as the legislature to make a father, a mother, or a grandfather and grandmother who just to express affection kisses a child on the mouth guilty of incest. Having said that, Chair, however, the one part which I do not properly understand in respect of the concerns of the beyond those who are in domestic relationships with one another, and it would seem that they are not in favor, only covered by the Protection Against Harassment Act. But I want to make the statement that I think it's quite clear out there that one focused or limited to only those who are in domestic relationships. And so, for example, ex-partners, etc., it's difficult to handle them in terms of the current provisions of the Act. And it must be a bit of a concern, I think, for us, and possibly if the presenters can unpack this further, in order for us to understand that this is not merely an objection because their workload might increase, but that there is rational grounds for them to seek Violence Act will be impacted negatively, and their work would be made more difficult or near impossible if those convinced, based on the presentation as it is, that this is not merely just opposition because of assisting victims of domestic.
Thank you very much. I think one of the issues that I think you raised, which I think we should really be encouraging from time to time, where we picked up issues, it's submissions where we so required, like in this case, SAP, if they so wish, based on the questions that have been raised. But it should be between now and before we start with the deliberation, so that we can be better enriched. Honorable Swart.
Thank you, Chair. And I think we all accept that GBV, gender-based violence, is an issue that faces all of us as leaders and society, can be an improvement. And so we welcome these submissions. We need to look at it very carefully. One of the issues that came up in the previous submissions relates to the implementation of existing legislation by law enforcement, which involves the police. Mention was made of the frustration with police, with implementation be an ongoing issue which we'll be faced with these pieces of legislation. How can we assist with the implementation as leaders, knowing already the constraints that the police suffer under with training, with sensitivity, with caseloads, with laboratories, you name it. There are, and with the huge backlog of cases that has been faced with. That is the first issue. You do highlight a number of issues relating to unintended consequences that we would need to look at, but one, Chair, would presume that the Department of Justice, the legal advisors, and the police would now meet to discuss those issues. Clearly, you've already engaged in the cabinet process with the bill coming to us, but one, in the normal course, that would also happen now that there'd be an engagement to look at your concerns and to see to what degree they can be allayed with a meeting between you and the Department of Justice lawyers and the police. And I would urge that that does happen as well. It's interesting that you raised the issue of the kissing, because that was that whole bill. When we drafted that bill, became known as the kissing bill, and because of those issues. So those are issues that we look at. Clearly, the law does provide for de minimis non curat lex, but you don't want to have any unintended consequences. I would also like you to comment. You might not be able to do it now, but again, relating to implementation is the costing of the implementation, given the possibility of broader definitions to include the ambit, which we need to consider, because clearly at the moment we are not succeeding with fighting gender-based violence sufficiently. And so that could be the reason why the definitions are being broadened, but that would clearly have an impact on the resources that are needed by the police service, by the detectives. And lastly, I would just ask you to then comment on the relationship when it comes to law enforcement and the clusters, criminal justice in general. We know from the presentations that we've received from the Department of Justice, there are severe challenges with the court process at the moment, with the backlogs. The prosecutors are doing their best, but now to enable us to fight gender-based violence, we are going to need more resources and a very dramatically improved criminal justice system, which is something that in the immediate term, given the financial constraints that the country is faced under, would not happen overnight. So these are some of the issues we need to consider as well. Thank you, Chairperson.
Thank you very much, Honorable Mfuke.
Thank you, Chairperson, and thanks for the presentation from South African Police Services. Chair, I want to align myself with my colleagues, Honorable Swart and Honorable Horn, and even yourself on the issue of the first, it will be on the issue of the supplementary submission on the amendment, because I am not convinced. I don't get it, because I find South African Police Services failing us in that regard, and I am really very worried that this doesn't actually embrace what organizations are saying. I think Honorable Swart is correct to say on existing legislation, you have a challenge already. And I'll tell you one challenge that you are having is your domestic violence register that you never used. How are you going to be able to deal with what is coming out with the bills? Are you ready to be training police officers? And on the ground as a public representative, I know that most communities are blaming police on the failure of the existing GBV, a Domestic Violence Act, because you failed in many ways. And I'm saying it also that why don't you talk to your mom, or because it's your father or your uncle, talk to your family, and the case is withdrawn. And I think I will agree with those communities that are saying we don't have to allow cases of GBVs from now on to be withdrawn, because the blame is on you, noting the challenges of budget. I agree with my colleagues. Talk about training when we don't talk about the budget. That is something that when we talk about the GBV bills, we must attach the finances into that. I agree. But the issue of cases that are failing, when you talk about the Department of Justice, is the end product. You'll tell us that there's no conviction, but the beginning of it is where we are failed. And I'm wishing that we can get more from the police officers, because you are an entry. You talk about social workers that should work with you. How many do you have at the moment? You don't have them. The relationship is not actually even there. When you check on the numbers of the social workers that are working with you, they are actually coming on other days. And those are things that will be worrying one to say that how are we going to win this battle when the entry as police officers are not ready? The last one is that as a woman and as Brigadier Van Rooyen, most of officers that are working in these cases, you find that they are abusers themselves, or we don't even know what kind of behaviors they are having in their houses. How are you going to detect them? Because we don't need secondary abuse when people come to your police stations, because it's there most of the time, and I repeat it, people are failed by the South African police services at the entry. Not blaming you, but I'm saying that let us support these bills and work together and come with the supplementary submission on this and see what will happen. But at the moment, thank you very much.
Thank you very much, Honorable Mpukeng. Honorable Nivo Drachens.
Thank you, Chair. Can everyone see me? Right, thank you for subs for your presentation. I must admit, as I read through SAPS's presentation,
We want to see Velma. Thank you. Committee Chair, we want to see Velma.
Yeah, can someone spotlight Vilma? IT, can the host spotlight me quickly? Wilma.
I can see Wilma. I can see her.
Okay, so thank you, Chair. Just thank you for the presentation. And SAPS, yeah, thanks. I must admit that as I read the presentation, I became a little bit worried. I myself, as a woman, become scared. If this and these arguments are, it's not sensitive to the victims. It's not. So please, it's more for the abusers. The victim must prove. The victim must prove so many things, and I'm worried about that. There's a lot of domestic violence. There's so many cases where children and women are abused, and doesn't get any success towards prosecution. So I'm wondering, what is the perspective of the police in terms of this? That the one thing when you spoke about the elderly abused, about the isolation. Does it need more of a definition? I want to know why, because sometimes if an elderly person is locked up, they have to stay in the room, they're locked up, they're not given any food, they're not, is that enough for SAPS to know that that is elderly abuse? Isn't it enough to know? And then I have a concern when you said not all domestic violence itself. What is the definition? I repeat, you said not all domestic violence are offences. So now, what is SAPS's perspective on domestic violence? What is domestic violence to SAPS? And I went to visit a TCC center, and I just wanted to see what are the problems. And why do people say that they don't know that TCCs exist? And I asked the question, the police in the area close to the TCC centers, do they know about the TCC? And the manager of the unit manager said that all SAPS officials are in the forums when they discuss information, etc., about the TCC. So I find it strange when I ask people, when there are children who are molested, who are referred to TCC, are they referred to TCC centers? Because there was an advocate to ask for money to get private counseling for children. But at the TCC centers, we have these resources. We have good resources and we have counseling. And the advocate told me that the family doesn't know about the TCC center. So now the first point of entry when you report a case is SAPS. Do all SAPS officials know about the existence of TCC centers to provide the service? And then you said there's a concern that if you have to arrest both the victim as well as the perpetrator. Now, you gave the example, I'm the abuser and I push a person. That's already violence. Now I'm asking, if my child sees me being abused and my child pushes the abuser to protect me as the mother, should my child also be incarcerated? I believe it becomes the officers also needs to act as a social worker to find out what happened, what caused the tension for them to phone SAPS in the first place. Now just immediately incarcerating both or locking up both, to me, I can't judge that. Now, there are safe houses. There are safe houses. We have these safe houses, and you can take the one who caused the violence out of the situation until they come to court. But at the same time, you inform the victim. You can't just incarcerate them and add to the trauma of the victim, but you let the victim know that when they either stay at home or they move to a safe house. And then tomorrow when the court case appears, you have to be there. I'm like I can't find clarity why you would say that you would lock up both parties. It's too much trauma to the victim already.
Thank you very much. Over to you, SAPS. Presenters, please also take note of, also take those into consideration.
Thank you, Chair. In response to Honourable Horn, he raised the issue that related persons, the position should be clarified. Close relationship to the complainant. Now, first of all, that is a vague term. Is my neighbour in a close relationship with me? Is my psychologist with whom I share all my deepest thoughts in a close relationship with me? Does it mean that my psychologist are the matters that we have concerns about? First of all, Honourable Horn, ex-partners are in a debate together with the perpetrator. It does not mean that the domestic relationship has ended. The definition of a domestic relationship includes persons who are family members, who are parents of a child, who are or were married. It even includes a one-night stand. So it means literally a lot of people with whom a complainant had or has a relationship is still in a domestic relationship, even though the person is wide and already includes ex-partners, also parents of a child, irrespective of whether the parents are still together. I think in that regard, it's quite important just to indicate that the related persons terminology originated or is actually contained in the Harassment Act. And I think we should also consider amendments to the Harassment Act to address a number of concerns that we may have in respect of relationships wider than domestic relationships. The Domestic Violence Amendment Bill should not be the only legislation to deal with all kinds of relationships, because there will be relationships with persons that are not in a domestic relationship, but who are still important in the life of a avenue to address that. Honourable Swart, you mentioned a number of matters regarding the implementation and resources. And I think in this regard, one of the provisions or proposals that we really support is the involvement of other departments as well. Domestic violence cannot, and it really requires a consolidated and cooperative approach by government departments as a whole. I mean, if you consider the Department of Housing has a responsibility to provide housing to victims. Now, normally, if you look at domestic violence, you only think about the involvement of a criminal justice system. But that is not correct. There's quite a number of other departments, difficulty and the problems that are created by liquor in respect of domestic relationships. So really, this is a piece of legislation, or this is a scourge in society that requires all state departments to be hands on deck, that domestic violence is properly addressed. I mean, we need to start not only when the domestic relationship, we need to start by making people aware of the danger of domestic violence. That means we have a responsibility of educating people. You know, despite all our efforts, we still need to start by reiterating the fact that a boy child is not stronger or more important than a girl child. That means all of us will, even in our own homes, have to instill the belief that girl children are just as important as boy children. So it means we need to really ensure that from a household perspective, we start to reiterate that responsibility and the fact that there's no differences between boys and girls. They are all equally important and they share the same dignity and importance in society. I think also in that regard, Honorable Swart, you mentioned the costing, and yes, we will be able to cost the implementation of the bill once the bill is more advanced. In other words, where we have more clarity on the exact provisions. But I think we must also consider the steps already taken. The proposals in this legislation dealing with bail, in other words, that cases of domestic violence cannot, a person, a perpetrator in cases of domestic violence cannot be released on either police or prosecutorial bail, and that the person will have to appear in court for his bail application. That is an important development. Furthermore, the strict sentences, especially in respect of repeated offenders, are also something that we fully support, and we believe that that will also be a positive development. But we must also consider the proposals or the legislative amendments already brought about in respect of the sexual offences courts. That is quite a valuable development to address and to assist victims of sexual offences. The DNA regulations and attempts to ensure that there's proper analysis of forensic evidence is a priority for the police service. You know, if you consider the implications of gender-based violence, it extends beyond a family, but it deals with violent crimes. That is a problem in society, and that we in the police consider as one of the priorities. We have also already addressed the appointment of forensic social workers to assist especially child victims. And in that regard, the police have also strengthened the FCS units, the families, child protection and sexual offences units, in an attempt to ensure that victims of domestic violence and sexual offences receive proper care. Where police stations also have victim-friendly rooms to ensure that the victim of any crime, which includes domestic violence and gender-based violence, receive the necessary protection and are dealt with in the privacy of a accommodation for a night and secondary traumatization. We also have forums, victim forums on different levels of policing, albeit at station level, provincial level, cluster level, and of course national level, where we engage with different departments, as well as Honorable Kukeng. You mentioned that the domestic violence, the police has already failed victims. That is unfortunate. I really feel that that is unfortunate that that is your perception. I think there's a lot of police stations that do good work. Of course, we can also improve, but it's also important to keep note that are, and I think the developments of incorporating responsibility on other departments to take part and to support efforts of government to address gender-based violence will also be a positive development to ensure that other departments can assist the police and to strengthen our hands in addressing victims of domestic violence. You mentioned the perspective, the social isolation of older people. And in this regard, it's important to note that there's already a Protection of Older Persons Act. And in terms of that act, the police service can similar to the case of the provision contained in the Children's Act, remove a perpetrator who abuses an older person. So that act already provides for, so that may be something important. I realize that older isolation, the difficulty that we had there, but it can be strengthened by ensuring that there's a definition to avoid the subjective interpretation of different persons on what is elder isolation. You also mentioned that I mentioned that not all domestic violence is an offences, and that is true. Keep in mind that domestic violence, there's no offence in South African law called domestic violence. Domestic violence consists of two requirements. The first one is there must be a domestic relationship. In other words, the victim and the perpetrator will be a couple who are married. And then the second requirement is there must be some assault. The offence is not domestic violence. Certain forms of domestic violence does not constitute an offence. For example, I buy a fridge and I have a gambling problem. So I take it to the pawn shop and I squander my salary. As a result of it, my partner is unable to care for the family, and therefore we sit in a or responsible with my salary and do not take care of my family. Does not constitute an offence, but it does constitute domestic violence if it is perpetrated within a domestic relationship. And in those circumstances, the law already provides that the victim can apply for a protection order that compels the perpetrator not to squander his money. You mentioned also that TCCs are, whether they are known in the police, and they are in fact well known in the police service. And as you rightly pointed out, there's different forums where they participate and also make use of other existing NGOs and services provided by civil society to assist the police station within that specific area of policing. I think it's also important once again to reiterate the necessity of education. I have noticed for the past couple of months, there's definitely a heightened awareness of domestic violence and gender-based violence. And I think we cannot reiterate the importance of that message being shared consistently. People must at all times be made aware. Honorable member, you also mentioned, provided an example, if a child, for example, intervenes by protecting his mother and he pushes the father, who is the perpetrator of domestic violence, in terms of a proposal, the child will have to be arrested because the child is in a domestic relationship with the father, and that is exactly the problem that we have. The fact that there is no discretionary power, but an obligation to arrest when there's an act of physical violence means that even if the victim does something that constitutes physical violence, pushes away the perpetrator, that pushing away is an act of physical violence. And if this proposal is adopted in legislation, the police will have no choice but to arrest both the father and the child who intervened on behalf of his mother. And that is exactly the problem that we have with that proposal. You mentioned safe houses, and indeed safe houses are important, but if this provision is adopted in the legislation, the police will have no discretion or choice but to take both parties to police cells, because the power to arrest means that you must take the person to police custody and not to a safe house. And that reiterates the difficulty and the concerns that we have in respect of that proposal. Thank you, Chair.
No, thank you very much, Brigadier Van Rooyen. But I must state from the position of chair that I am extremely worried. I am extremely worried about the posture that I think it's being taken now. The issue of gender-based violence is a national crisis. That is why the head of state took it upon himself to push it. Now, the impression I'm getting is that departments are continuing with their silo mentality and silo approach with regard to this issue. You, as the police, you serve in the DG's cluster, where your national commissioner is represented. Your minister and your deputy minister serve in the JCPS cluster, which is a cabinet committee, and this bill has been through that cluster. This bill has been through cabinet. And now when this bill comes before us, the police are raising issues which will processes. My difficulty is, it's quite clear that in implementation, these things that you are raising, which indicates that we still have strong remnants of silo mentality, are going to undermine the implementation. It's not something that we think you must respond to it. You think that your leaders should take responsibility. If cabinet has adopted this bill, were police concerns taken on board, because a fight against gender violence will not succeed if there is no concerted, integrated approach by the whole of government and society. These differences for me, either in interpretation, in the interpretation of the law, in differences of what needs to be done, already for me, they are signaling serious disaster that is coming. And I think as members, when we deliberate on this bill, or even before we deliberate on this bill, we should really look at that matter. There is no point of having your DG clusters, your subcommittees, your cabinet, where all these bills go through all of those bodies, and then when you come, you have such divergent views. I really do think that your leaders should come before the committee. Justice, both justice and the police, we should get an assurance as to how is this bill going to be implemented. Because there is no point of us trying to push and meet the deadlines, which means the systems and the processes of government have not been able to deal with those particular issues. I think it's something that we need to come back to it, because I'm deeply worried about it. Thank you very much, Honorable Janji.
I want to quickly support you, Chair, and therefore your process, just to endorse your process, that let's go through the public hearings. As you say, we park this issue. Remember when the department came to present this, we asked them about their capacity of implementing this and on all other issues. So I want to agree with you that we're not going to leave it to them. As a committee, after when we deliberate, we also ask them, and we put our views forward so that the committee can just highlight this issue. It's a serious matter. Otherwise, we're just playing if we continue this way. I just wanted to support you on that, Chair.
Chair.
Thank you very much, Honorable Janji. Honorable Jelly.
Comes after.
Okay.
Let Jelly speak first.
Yes,
Honorable. No, thank you, Chairperson. No, I wanted to write even before Honorable Jaji writing in support of what he has just said. And definitely, Chair, we have to zoom into this one.
Thank you very much, Honorable Mufike.
Chairperson, thank you very much for the summary, because I was very clear what I was saying. Because being the person that sits also on police, I'm very disappointed. and the fact that there was a DG acting who was sitting in the submission to the cabinet, and then something like this comes out, we have actually a responsibility to make sure that they come again. The law today, it's a disappointment to these 3 GB bills. And I still go back to say the South African Police Services has good men and bad men. But today we have seen that if we don't shake up that, we are going to go back to what we don't want. We must win the battle of gender-based violence and no other way. And I still say that the police service is an entry. The good police officers that are there, let them work. But those that are not willing and come up with interventions like this, we cannot really go there. It's undermining Parliament and undermining the cabinet. Thank you very much.
Thank you very much, Honorable Swart.
Chair, I want to just add that it's important to bear in mind the process, and I agree with you as far as the cabinet committees are concerned, and the bill haven't gone through that. But it's very important, given our timeline now, that as I suggested, and that would normally happen, is that the police and the department would meet to discuss those issues that have been raised and those legal queries that have been raised. More process of public hearings as issues come up. The Department of Justice will consider the issues, and where state departments would meet or with other interested parties to try to alleviate the differences. And I think that's also a key part, to hear the legal concerns that were raised, to see whether there is a validity in that. But I agree with you on the implementation side. That is a massive concern for us as legislators, so we need to take that. Thank you, Chair. Thank you.
Thank you very much, Honorable Newbold Graham. The department is, I think it's here, it's listening to answer you. Let's go to the next presenter. I think it's Center for Child Law.
Thank you, Honorable Chair. I just want to, if the host could please start sharing my presentation. I'm not able to do it from my side. It's the Center for Child Law. My name is Zita Hanzungule. I'm a senior project coordinator at the Center for Child Law. The Center for Child Law is a registered law clinic that works to advance the rights and best interests of children in South Africa. We do this through litigation, advocacy, and research. We have worked on various issues in regards to the advancement of children's rights in South Africa. And some of these issues include the advancement of the rights of children who are victims of sexual offenses and other violent offenses, as well as on the other side, the advancement of the rights of child offenders and ensuring that there are systems in place to rehabilitate and reintegrate child offenders. And it is from this basis that the Center for Child Law made submissions to the 3 bills, the gender-based violence bills. I will focus mainly on the proposed amendments made to the Sexual Offences Bill, and specifically in relation to the national and the further bill. So touching on the National Register for Sex Offenders, I'm going to start by saying that we acknowledge the importance of ensuring that the law is aligned with society, with South Africa's view to ensuring that gender-based violence is eradicated from society, including children who are often one of the most vulnerable members of our society. So we support in line with submissions that have been made before. We believe that legislation and implementation of legislation and any other steps put in place must be done in a manner that has been mentioned just now, aligned, that ensures departments are working together with realities of other members of vulnerable groups. So on that basis, I'm going to go into our submissions specifically in relation to the National Register for Sex, are raising concerns specifically around the effectiveness of the proposed amendments in protective rehabilitation and reintegration of child offenders. As the Constitutional Court has mentioned before, in line with the Constitution, children who commit crimes are required to be treated differently from adults because they are more prone to be rehabilitated. The Constitutional Court has stated they are more malleable. It is possible to rehabilitate them and to reintegrate them into society. So these are the effectiveness of the proposed amendments in protecting vulnerable people, in our case, vulnerable children. Firstly is something that was raised by the Children's Institute earlier, and we support the submissions that the Children's Institute raised, is the maintaining, running, and monitoring of the National Register for Sex Offenders. We believe at the moment that it is not being maintained in the manner that it should be maintained. Figures were raised for the 20 register, whereas in that same year, the South African Police Service reported just above 20,000 sexual offenses committed just against children. This is so what was validated on the register is far below the offenses committed against children. And this raises the question of, is the sex offenders register being utilized in the manner that of the Act? And this is, and we believe that it is not. We believe that there are many gaps in information that is supposed to be collected, that is not collected, that is not on the register. Therefore, many gaps in checking people against the register. So you will have, for example, some people who have committed sex offenses but may not be on the register because of the insufficiency of resources and capacity that has been placed on ensuring that the register is populated sufficiently. And this is going to take us into submissions that we have in relation to making use of the South African Police Service record system instead. A further concern that we have, the second concern that we have, is that while the National Register for Sex Offenders focuses solely on sexual offenses, and this is important because we need to ensure that vulnerable persons are not put in contact with those who commit sexual offenses. We also believe that it is important to ensure that people who have committed other serious offenses are also disqualified from working with vulnerable children and other vulnerable groups. And examples were raised earlier of let's say, a driver who has a past criminal record of driving drunk, and this is somebody that is driving a school bus. Because there isn't an obligation to check against, for example, the SAPS records, that won't come up, and that won't come up on the National Register for Sex Offenders. So this brings us to our argument. So both of these concerns that we have raised in our submissions brings us to our argument that we believe that the National Register for Sex Offenders is not the enhanced protection that is required for vulnerable groups, because the sufficient information is not on the register, and secondly, because it does not cover all the various serious offenses that are outside the ambit of sexual offenses. So it is our submission that the SAPS system, which contains information on any person found guilty of any crime that is a sexual offense or otherwise against children or other persons or other vulnerable groups, should be used instead of the National Register for Sex Offenders or the register under the Children's Act, as previously mentioned by the Children's Institute. Our submission is that the SAPS system contains all the historic data necessary as up to most recently, and using the SAPS system would ensure that the limited resources are pooled. So this comes back to the argument, the arguments that members of the committee are making just now about the departments working together, SAPS and Justice Work, and using the one system that has been working sufficiently for a number of years, strengthening that system and saying that this is the system that we're going to use to check people who have committed sexual offenses or to check people who have committed other serious offenses, including sexual offenses or outside of sexual offenses. And this could be worked into legislation. So this could be worked into the Sexual Offences Act. So instead of refer to the Sex Offenders Register, referral could be made to the SAPS register. Another example I could give is a care worker or a teacher who has a criminal record of physically abusing vulnerable people, but not sexually. Next slide, please. I think the other thing I'm going to the fact that it would be more sustainable and more practical to use the SAP system. The Center for Child Law has had first-hand experience in difficulties when attempts are made to access necessary information from the National Register for Sex Offenders. We were involved in a case in the Constitutional Court, where the Constitutional Court ruled that it was unconstitutional to automatically place the details of children on the register, and that children should be able to argue to court details on the National Register for Sex Offenders available to us, so that we could follow up with children who were on the register at that time to see if they needed any assistance to approach the courts. And we have made various attempts over a number of years to access that information together with legal aid. But to this day, we haven't been able to access that information. And that shows, just from the perspective of the center, how difficult it is to access information from the register itself. And I do admit that the experiences of the Center for Child Law are not necessarily the experiences of everybody else in terms of the sort of information that we're trying to access, but it does point to the fact that there are difficulties in the processes related to accessing information from the register. So all of these 3 points brings us back to the fact that it is very quick to, relatively quick to access information from the site, and we believe that it would be a better use of resources, manpower, and capacity to focus instead on using the SAP system as a system that we can use to access information like sexual past sexual offenses committed or any other serious offenses committed. Because how the SAP system works is that when I'm convicted of any offense, my fingerprints are taken and my details are put on the SAP system. Therefore, my details are already there. And that is why we submit that the SAP system is the best system to use, and we therefore support the Children's Institute's submissions in this regard as well. And then the second submission that we have to make is in regards to making particulars of persons convicted of sexual offenses publicly available. Now, we only make these submissions only in relation to children who are convicted of sexual offenses. And we are particularly concerned about the reference in the includes child offenders or people who were children at the time of the commission of the offense. And this takes us back to a point I had made earlier, that the Constitutional Court, South Africa's Constitution itself, is very clear on the fact that children who commit crimes, whatever crime they commit, including sexual offenses, should be treated differently from adult offenders. And this is because children are it is more possible to promote their rehabilitation and reintegration. And this has been affirmed by the Constitutional Court in various cases, which I won't go through now, but they are available in the submissions that we have made on pages 5 and 6. Yeah, on pages 5 and 6. Just to say that the Constitutional Court has, in various circumstances, belabored the point of the ability of children to be rehabilitated, the ability of children to be reintegrated, the ability of children to be diverted from the criminal justice system, and in a very basic sense, taught a new way of doing things, taught a new way of thinking about things, and also the ability of people who are working in child protection systems in the criminal justice system to go into the children's families and say, why is this happening and how can this change, so that we can change the trajectory of a child's life. And our argument is that when you make a child's information publicly available, we are then exposing a child to trauma, to stigma, exposing a child to a situation where it is more difficult to go through the rehabilitation and reintegration process because all of their information is out there. And most importantly and additionally, we argue that making children's identities publicly available would be in contradiction with the finding of the Constitutional Court that was made in 2019 in the case of Center for Child Law versus Media 24 and others, where the Constitutional Court made it very clear that the identities of child victims, child witnesses, and child offenders, and revealing their identity is unconstitutional. And the Constitutional Court actually ordered an amendment to the Criminal Procedure Act in this regard in order to protect children's dignity, privacy, and their best interests. Next slide, please. Right, then our third set of submissions is around definition of vulnerable persons. Now, the center is not opposed to the general idea of providing protection to a broader group of vulnerable persons. However, when one looks at the definition that's given in the proposed amendment at the moment, an argument could be made that the definition of the definition currently given is not broad enough. And that we could go even broader and protect, for example, members of the LGBTQI community, or as the ANC Women's League had mentioned earlier, why are we limiting to the age of 25? So I think a broader consultation and broader thinking needs to happen around that. And at the same time, it takes us back to the argument of using the SAP system, is that when we make it a broader group of vulnerable persons, the SAP system already has that information. And we will not then have to belabor the National Register for Sex Offenders, which is already having issues in terms of implementation and monitoring. Next slide, please. Then our next proposed amendments talk to the inclusion of details, of new details on the National Register for Sex Offenders. So now these proposed amendments make the details that need to be included on the register broader, because you're not only looking at people who've committed crimes against children and against persons with mental disabilities, but we have broadened the group of vulnerable persons, which means more resources have to be put in place to ensure that about our concerns around capacity and resources at the moment, just to ensure that the right information is available in relation to children and persons with mental disabilities. Now, our worry is that when we broaden the group, it's going to place more pressure on a system that is already struggling, and this would mean that some possible litigation in that regard. And our submissions then point to figures that talk to that talk to the levels of sexual offenses when you look at a broader group of children, and just how much work would have to be done. And how much time would have to be put in to ensure that the sex offenders register is updated in that regard. And it takes us back again to our argument of using the SAPS criminal record system, because it already has the historical data, and it is day by day updating this data, and it would be the easiest system, the most practical system, and a system that ensures better access to justice, and it would avoid any possible claims of discrimination. And I think our last presentation, and this is something that the Children's Institute already raised, is the duration of these details remain on the register. And we find this concerning specifically for children who commit crimes and who have the potential for being rehabilitated. And we submit that the duration of children's details remaining on the register should be looked at very seriously and very critically, because we submit that this should not be the case for children, that the duration of their details remaining on the register, if they are placed on the register, should not be increased. We accept that there is a section in the Act that allows for children who are on the register to apply for the removal of their details at any time before the expiry of the time period. However, this exception erroneously assumes that all children have the capacity and the resources to go to a lawyer, to tell a lawyer, or to ask a lawyer to represent them, to have the money to ask a lawyer to represent them and say, could we go to court and have my details removed before the time that they automatically come off. So we need to take into account, as a whole, we need to take into account the principles articulated of children's malleability, their potential for rehabilitation, reintegration, and we believe that it is of importance to look at how this whole system works in relation to children who are victims of crimes, as well as in relation to children who have committed crimes themselves. Those are all of my submissions, and I look forward to receiving questions.
Thank you very much, ma'am. Thank you for the presentation. I will now note hands from the honorable members who would want to engage with the presentation. I'm not seeing any hands. I have Honorable Mufokeng.
Thank you very much, and thanks for the presentation from Center for Child Law. I think we really need to thank them because they flow very well with the.
Thank you very much.
Chair.
Honorable Miller.
I think yes, let's appreciate this her presentation, and also noting the issue of children, those that have to remove themselves when time comes, Chair, those that issue after rehabilitation, the child at a certain age experiences problems of removing himself or herself from the register. I think that is the issue that I really, it just opened my eyes. But we appreciate the presentation because it touches in many of the presentations that have already been done. Thank you very much, Chair.
Thank you very much. Are there any further hands? None. Let me scroll down to check if I don't leave anybody behind. None. No, thank you very much. Thank you very much, ma'am, for the presentation and also for drawing our attention to the Constitutional Court judgments. I think they are very helpful. Members, this is the last presentation for today. I think if we can just remain for a few minutes just to deal with some housekeeping issues as to how do we approach the remainder of the program until Tuesday. We can release everybody else who wants to leave, and can members please remain behind? I think maybe let's take a 5-minute break so that we allow people to leave and for members to settle. Let's just allow 5 minutes break. We'll come back at 10 to 1 for 5 minutes. Thank you very much, members.
Thank you, Chairperson.